old man, the government servant, he's been convicted in the court below man under section 408 and 409 man, and NBW has been issued man.
So NBW issued is not executed.
No, not executed, but
what is the pressing urgency? It can be, you can wait till Monday. No, you can Monday, list it on Monday. List it on Monday. Monday. Let it be listed on Monday. It's a request Monday. Monday koi nahi, let it be listed on Monday, don't worry. Huh? Yes. Wait, seniors are there, go by it. Give some respect to the seniors.
It's a matter of 2024. My endeavor is to either for mediation or early disclosure. We both, I mean the informant and the accused, are a business entity.
What is the offense?
Offense 468, 67, all this. We have been cheated by 20 lakhs. They have deposited that amount as a bail condition also. So let it be either to mediation, early disposal, or whatever. Because my money is...
I'll get it listed. I'll see.
My money is...
See, adjustment. Yes.
Grateful.
Yes, now.
May I please, Lord?
Yes.
May I please, Lord?
Okay. I'll take it 12 o'clock. 12 o'clock. 12 o'clock. Yes.
May I please, Lordship? My lords, a mistake on my part, my lords. On Tuesday, a matter was listed at item number 126. By mistake, I could not appear, my lords, and non-appear, the interim order has not been extended. No, only play any day, Lordship.
What happened then? But
I was not there on that date.
What is the order passed in that?
Non-appears put up on 20th of December, my lords.
Simply adjourn, what is the problem?
Interim order has not been extended, my lords.
There was an interim order.
Yes, sir. This is that case where the company has not been addressed as accused and the...
It is already uploaded. Already uploaded.
Oh, sir. So the non start key not to the value and encoding. So key not to the place we keep any more model. Go set to key.
Monday, I'll visit. It's all right. You should have demoted some.
My apologies. My apologies, sir.
Monday, I'll just list it and exchange it. Yes, yes, sir.
This matter which your lordship kept it for judgment. For your lordship's reference, can refer the
please, that is very.
Of that judgment Madras High Court, along with one article by a lawyer, which will helpful in regarding splitting of a case in what circumstances is the duty of the trial court, etc., etc.
Yes.
Along with the judgment Madras High Court.
Madras High Court, which paragraph you are relying upon? Do you have any idea?
That I have not mentioned.
Okay. I'll just read it.
That will mention in the article.
Give it to me.
I have given last date is 2nd December.
I'll just deal
The
it.
2nd December. Here is stay was there, in the other cases also stay was there, which was not extended by.
I'll just see that. Give it. You read it and give it in the lunchtime. Don't.
Can have the reference, they have got very big machines.
And if you are adding something, and please intimate him. And rather you read it and tell me the relevant paragraph. And read for him, huh? Read for him also. Read for you and read for you.
This is cryptic order. The solicitor has to record satisfaction. Is your possible?
Yes. Pardon me, Lord. Review petition 2018. We have several.
2008.
18.
Review petition. Give it, we'll see. The
Date may be fixed, my lord. It may be.
Fix it, please.
Fix a date, my lord.
It is a bail jump printer, my lord. The petitioner had to give it. Bail jump. Monday. Yes.
Date may be.
He'll fix a date and take.
My lord. One is a Belgium matter and three is a compromise matter, entry matter extend.
Compromise, offense at both sides file offense.
2 case 506 only. I was a 307 and a CC Act. Both party appear and file their joint affidavit. As per my
307, what are the injuries?
Injury is a simple one. As a
it's simple, then I'll take it.
No.
Bail jump. Which is bail jump? You tell me Monday. Bail jump Monday, and the other one? 2 compromise matter. One is 506, another is
386.
and another is 207.
506 2 cases. Case a counter case. Both party appear and another case is 307 along with the SCS Act.
cross cases.
Right.
List for them.
Obliged.
Yes, sir.
Item 20.
28.
Right.
Is there an interim order?
No, yes.
Oh, urgent.
Item 10, my lord.
10.
Item 10, no change there, and taken 1 week after.
Sorry?
And taken 1 week after.
It will be urgent, that's all.
Yes,
Urgent. February.
Item
Pardon to
15.
my.
Can it taken out next week?
Sorry?
Item number 15.
15.
Praying for an adjournment.
It will go to February. Those who are asking for adjournment, it will go to February. Press matter, if you don't want to do, let it be.
Pardon, my lord. Item number 88, my lord.
The year 18, my lord. CLMC. The present petition challenge the Cognizance order, my lord. Will not come, my lord.
2018.
18.
You have settled the dispute. Have you settled the dispute?
No, not 420 allegation.
Okay, you give it, we'll see.
100.
Let's see.
I pray for an adjournment, my lord.
Which one?
100, my lord.
100.
Yes, let's see.
Interim order is there.
Yes, yes, sir, let's see.
So then why adjournment?
My lord, my seniority out of session. That's why I pray for an adjournment.
Sorted. So, interim order. Yes.
Pardon the mention, my lord. One tied out matter, my lord. Filed I have to interim bill. Yesterday morning, my lord, the mother of the present patient died, my lord. Kindly taken after lunch, my lord.
Monday. Give the particulars, he will verify it.
My lord, already
Otherwise, Monday again it will be
my
urgent.
lord, already solved, my lord.
Sir,
Item number 88, permitted to withdraw, my lord.
88 withdrawn. Yes. 88 withdrawn. Yes. Any mentioning?
Item 2, my lord. I play item 2.
Item 2.
My lord, petitioner's advocate is going to marry 2 days. That's it. January.
Sorry, what do you want?
Case and counter case, my lord. I am OP2. Case and
Okay.
counter case, my lord. Both the matter. Compromise has been made, my lord. 307 is there, lordship, because council is going to marry today. Is married.
Okay. Personal difficulty urgent. Huh? First week of December or second week of December. Tick. Okay. So,
Well, obliged.
Item 8, lordship. I pray for short order afternoon, lordship.
item 8.
Lordship.
Press matter. Why are you seeking urgent?
Lordship, I have some personal difficulties. File a term with me, lordship.
Yes. Any mentioning? No. Yes. Start.
68.
It will start from 60. It will be taken apart. What is this matter? Then I'll take. The problem is it is specially assigned to one particular.
This is a tired matter and the court.
So unless it is again assigned to me, I can't take it. The problem is that
He was not given any particulars what examination he give and nothing is there, man.
except tied up matter, that's the problem. Okay.
Case.
Hey, is there the examination is fixed? Examination is there?
Examination, my lord, nothing, no particulars he has given. Only it is examination good. Only a slip has been given that examination is scheduled. Identity card, key, code examination, no, nothing is there.
Hello, I am not taking your point. Okay. Release. Yes.
Item 5.
Item 1, my lord, is a case of 30, case and counter case.
Yes.
302 is there, my lord.
What is he asking for?
In the initial, the first case, the 506, 294 and of the other offences are there, proceedings submitted. 323, 506, 294, 300. There is a, at the time of Ganesh Puja Gosai, there is a the quarrel taking place. And he is stabbed in a knife in the belly of the deceased.
Yes.
And he died. Subsequently, case turned to 3-0. The initial case was registered on 6-7, that was turned to 3-0. In the second case, tied up method.
Investigation is
Both the
completed.
cases investigation has been completed.
Completed.
Right.
Charge sheet has been filed.
And in the second case, there is also, it indicates that GC case is now pending for the sessions court. So, what have been draft has been comments because the charge sheet has been submitted in the year 2020.
Then
22 minor.
I'll just pass over and thereafter.
This will be disposed of because
Yes,
compromise
I'll dispose it.
cannot be compromised.
You can't. Yes.
In item 3, CBI is a party, Your Lordship, but Republic of India has been mentioned as the opposite party name, Your Lordship. May I pray that the name may be substituted with sin?
Well, that will be substitute. Yes.
We are not
What is this matter about?
Relating to demand of bribe.
We're challenging the FIR, Your Lordship.
Apparently, many in the criminal proceeding, client class coming pay 2 of the petition. I had reflected Republic of India bracket CBI, represented through its director, Central Bureau of Investigation. Only the wording Republic of India.
It's all right. Forget about it. Come to the point. Come to the point.
And tilted no counter filed.
Your Lordship.
Counter is not required. What is the case you tell?
Your Lordship, the notice is issued and passed the interim order. The allegation of a demand of rupees 5,000 in order to disperse the salary benefit of the private company. Here, pursuant to the said complaint, the case has been registered and the investigation has been completed. I am challenging the inter proceeding.
What are the grounds of challenge?
Yes.
It is a corruption case.
Let's correct.
Can't be quashed like this.
Like there is a good case for quashing.
Let us see. Let us see. You may be having a good case, but let us see. What are the allegations against you?
In fact, because of the wording of Republic, I am not well prepared with the brief.
But you have not prepared. Urgent. Huh? On request urgent. Meanwhile, change it. Change it.
I will file the consultation.
Okay. But prepare and come. You, see, corruption cases, quashing may not be possible. Let us see. Okay. Yes.
Much obliged.
Interim or same interim.
I'm much obliged.
Item 4.
Actually, my request is urgent today because I have to take some instruction from the I do say out of station confidential. So it's a passing of the cognizance, so I get some more time.
It's a cover matter. So
First week of first week of December. On the request of Mr. Marana, please the matter. Yes.
Item 5.
May I please, this application, I am seeking for quashing of the proceeding on the ground of compromise. The informant is my mother. Due to family disputes, as FIR has been lost.
What are the injuries?
Injury which na godela kati dhori ke etiki hochi alias.
There is no injury. Yes.
Yes, my lordship kindly see. हठात मो झील को मारधर कर सहित काटी गोटे धरी बोते हानिया गोड़े.
You are the son. You are the son.
Initially, you were drawn to the.
My lord,
you wanted to attack your mother.
नहीं नहीं टिके साइको अच्छे पिलाटा. माँ भी चाहूँगी से. मदर तो चाहूँगी.
What to do? 70-year-old mother. She can't come. She come.
No, he has not come. If a lot to direct, he can.
Why should I direct it? You have said.
File affidavit. You will not see.
You file affidavit. Then first week. Learn counsel for the petitioner submit that the parties have settled their dispute, and the informant is the mother of the present petitioner, and the allegation against the petitioner is not serious in nature. There is no bodily injury caused by the petitioner to the informant. Since the matter is already settled, he wants to file affidavit. Charge sheet has already been filed.
Charge sheet filed. Cognizance taken. Charge sheet.
And the copy of charge sheet. Affidavit and copy of charge sheet. Filed it, list it.
I have annexed that charge sheet.
Okay.
I have annexed that.
Deposition copy.
It's all right. Yes. There is no bodily injury. What?
Item 6.
May I please alert? I am on BC alert. This is a case for quashing arising out of a complaint case. Subsequently, it was registered as a Mahila case number 60 of 2020. And in the meantime, the petitioner husband has filed one section 9 petition, which is pending in the Judge Samil Court, Jashpur. And there is a possibility of settlement between the parties. If your RCP will issue notice to the informant wife so that the matter can be settled between them. This is a quashing because
You
after
want,
18.
you want that the court should be a party for your settlement. I will be
No,
instrumental.
I have made a party.
Courts.
I have made her party.
That's right.
I have
But
made
if you have settled, bring here.
this is a.
What are the
After
allegations?
18 allegations is 498 and other allied offences. It was made against the petitioner husband by the wife.
Family. Right. Issue notice.
Family.
Yes.
My pleasure, Lordship. My Lord, Allen's offences are 323, 324, 348. My Lord, on the amicable settle between the parties and both the parties are present before this honorable court.
Charge sheet has been filed.
My Lord.
I am for the OP number 2. I have already appeared, my lord.
Okay. What are the allegations, Justice?
My Lord, may I permitted to place the FIR?
Yes.
महाशय निवेदन है कि जो मु श्रीमती
Tell me, don't read it. Tell me what are the allegations.
ଆମ ବାଡିରେ ପଶିଯିବା ଜାମୁକୋଳି ଗଛରୁ ଢେଲା ପଥର ମାରି କୋଳି ତୋଳୁଥିଲେ ସେଇ ସମୟରେ ପାଟିତୁଣ୍ଡ କରି ସେମାନେ ମତେ ଦୌଡ଼ି ପଳେଇଲେ କିନ୍ତୁ ଅଳ୍ପ କିଛି ଦିନ ସମୟରେ ମୋ ଘରକୁ ଆସି ହଠାତ୍ ଆମ ଗ୍ରାମର ଏତିକି 6 ଜଣ ଲୋକ ଆମ ଭିତରେ ପଶି ଅଭଦ୍ର ଭାଷାରେ କହିଲେ ଆଉ ମତେ ମହାନ୍ତି ପ୍ରେଜେଣ୍ଟ ପିଟିଲେ ଏବଂ ବଳରାମ ମହାନ୍ତି ପିତା ଫର୍ଷରେ ମାରିଲେ।
Any injury?
No. Injury simple in nature.
Huh? Just see. Injury. 323 only.
My lord.
Charge sheet is taken.
324, 323, 294, 448 of IPC.
Yes. Injuries are grievous.
No, my lord. Injury is simple in nature.
Oh, so the problem is you people don't file anything. That's the whole difficulty. What kind of petitions are being filed, I don't understand. FIR copy filed and you say that compromise. What is the injury? What are the allegations? To what extent a court can give indemnity?
Only allegation is there. Actually, there was.
Show me the injury report.
Injury report. Since there is no.
Pass it over. Pass it over. Bring this injury. Let me see injury, whether it's serious, which part of the body.
My lord, I understand.
Compromise doesn't mean that everything will be allowed.
In some cases, my lord, in 307.
You show me in your entire petition where have you written it is a simple injury.
Yes.
In the petition, somewhere you should write at least. If you don't show me the document. Pass over. Next.
Item 9.
Belgium matter. Petitioner was released on bail on 12/4/2018, my lord.
24?
12/4/2018, my lord.
Yes.
My lord. NBW issued by the trial code 8/12/2023.
500. Yes.
Item 11.
Okay.
What is this case? Yes, Mr. Jana. What is
the case, my lord? The while the trial was going on, my lord, at that time the accusers came out from the jail and threatened the informant. For which case,
May please your lordships, I am appearing for BC Jajpur. There is a technical error. This is a Belgium. This is a Belgium matter, my lord. The
11, na?
Item 11. It's a Belgium matter.
You are on bail?
Yes, I was on bail on 18/12/2018. The accused petitioner. 18/12/2018. The accused petitioner was
22/2/2023. 500. Okay. Allowed. Yes.
Bhadrak Bar Association.
Yes.
Bhadrak.
Allowed. Na likh do. Viplov Kumar report.
Item 12.
One password, madam. Password. Mr. Das is coming. Yes.
13.
Belgium. And 12 is also Belgium? 12. Okay. 13? Yes. 13 Belgium. Tell me. No. NBW. Hmm?
When NDPS has been issued against him under Extortion war. Certified copy order passed by the Government Court of District and Session Judge and the in appeal number.
You tell me when he was on bail or petitioner was on bail. NBW was issued in 6/2/2024. 500. This is the one. Bail is good like
14.
My pleasure, Lordship. My Lord, alleged offences are 341, 323, 324, 307, 294.
What do you want?
My Lord,
Passing.
My Lord. My Lord, injury report was filed.
Offences are
307 is there.
My Lord, I was annexed the, I was also annexed the injury report.
1 minute. Injury. What are
Page
the
13.
Please, 13, my Lord.
What are the injuries?
All the above injuries are simple in nature. That is the page 13.
Okay. Least first week. First week. Yes.
Obliged.
16.
Question of criminal proceeding. Ordinance order is on this 3 at page 17.
Yes.
Offense target 350 that massive policy issued after 1 month of
After 1 month also they can explain it. That can't be a ground for quashing. Delay in registration of FIR is not a vital ground.
Government servant. Government officer.
Sorry?
Government officer.
I'm not able to hear you.
Government servant.
Maybe government servant. What to do? Government servant, this is also not a ground for quashing. You tell me on merits what you have.
What if in this,
Accident has already been filed. What are the allegations?
what if in your lordship, in this case, the petitioner earlier approached before this honorable court challenging order of cognizance that CLMC number 2009/2009, your
I have
lordship.
stated
And that CLMC is dismissed for default, your lordship. That page 19, your lordship.
19.
Yes, your lordship. Kindly glance for page 19, next 4. That order is print out from NATE online. Stands vacated, your lordship. Interim order there, that order was vacated passed in 2017, your lordship.
Yes.
Order that order is passed. Now in 2024, again the said by challenging the said order of cognizance, within president approach this honorable court for quashment.
I'll not. Right. The petitioner has challenged the order dated 17/10/2008 passed by SDJM Koraput in GR case number 481 of 2008, whereby cognizance of offences punishable under section 354 IPC has been taken against the petitioner. The next one, the FIR was registered on 9/9/2008. After investigation, charge sheet in the present case has been filed on 11/10/2008. The petitioner had approached this court for the same cause by filing CRLMC
2094 of 2009.
209 of 2009, which was dismissed for non-prosecution.
24/4/2017.
Why not dated 24/4/2017? 24/4/2017. Instead of the petitioner has filed the present petition, fresh petition seeking the same relief. I am not inclined to entertain this petition as the petitioner has approached this court belatedly, and his earlier attempt for the same relief has been dismissed for non-prosecution. Yes.
70.
May I please? When did the petitioner approach for quashment of the cognizance order dated 6/6/2023 and the page number 33? When did the case initially registered under section 188 379/34 reduced section 12 of the Mineral Mining Act? Thereafter, the petitioner deposited all the fine amount before the Tahsildar, for which the last phase, this Tahsildar had been given a letter to the IAC, concerned IAC, for withdrawal of the affair. But as there is prima facie evidence found, the IAC submitted the charge sheet and the learned court below
Has taken cognizance.
Cognizance only under section 379 and not for the offense 188 and 12 of Mineral Mining Act.
Yes.
Madam, this is the last phase in which the Tahsildar has been sent the letter to the IAC.
Tahsildar may say, but criminal offense has taken place. What to do?
How is it, how it is practicable for withdrawal of the affair? So once the offense is committed.
Offense is committed.
Offense is committed, but
admitted as a
he
deposited
deposited all the amount. And this is only for the lifting of sand.
Illegal
There was a theft.
Illegal transportation.
You were apprehended. You paid the money. Doesn't mean that the crime will go. Crime remains. That's a harsh case. What to do?
Whereas the presence of the informant is also highly improvable, as she is a IAS officer and at that time she is joined as Tahsildar.
On the ground of sympathy, I can't quash unless you make out a case. I have also the same sympathy for you. What to do? On the ground of sympathy, I can't quash a criminal case. Make out a case on merits.
Arjun, I will.
No, adjournment will not suffice. You argue all this point at the stage of charges. Okay. Petitioner has challenged the order dated 6/6/2022 passed by learned civil judge CJ bracket JD JMFC Atka in VR case number 186 of 2022, whereby cognizance of offense under section 379 IPC has been taken against the petitioner. The petitioner submits that the FIR, initially FIR was registered for alleged commission of offense under section 188/379/34 IPC, read with section 12 of Mineral Orissa Minerals Prevention of Theft, Smuggling and Other Unlawful Activities bracket close Act 1988. The investigation of the case was concluded and charge sheet was filed on 28/5/2022 for alleged commission of the offences punishable under section 188/379 IPC, section 12 of Orissa Minerals Control Act. The trial court, the court below, however, has taken cognizance of offence under section 379 alone. Then, consequently, the petitioner submits that he had returned the alleged amount. What have you
1,40,210.
He has refunded 1 lakh, so 1 lakh.
This is 37 has been realized.
Have been he refunded.
ଲକ୍ଷେ 40,210 ଟଙ୍କା
210 ଟଙ୍କା has been refunded. Persons thereto, the Tahsildar of the concerned area had written a letter to the IAC for dropping of the case. And despite the said letter, the investigating officer proceeded with the matter and filed the charge sheet, which resulted in the impugn order. I am not inclined to entertain this petition at this stage. As per NDPS, that prima facie case is made out against the petitioner. However, liberty is granted to the petitioner to raise all these points before the court below at the appropriate stage. With this observation, petition is disposed of. Yes.
Item system withdraw करके liberty to first to raise all the points.
Item 16. Item 16. Seeks to withdraw the petition. with the liberty to raise all the points before the trial court at appropriate stage. Yes.
My lord, item 13 permit to withdraw, my lord.
13.
Permit to withdraw, my lord.
Withdraw. 13 election. Withdraw. 6 to allowed it. Anyway. Withdraw कर दिया. Again one. 13. 1 minute.
Yes, my lord.
13. Why are you withdrawing?
My lord, he has surrendered before the Lanite court and released on bail, my lord.
अच्छा. Okay. Okay. Land counsel for the petitioner. 1 minute. Land counsel for the petitioner submits that the petitioner has already surrendered before the court below, and he has already been admitted to bail. Hence, this petition has become infructuous. Dismissed as infructuous. Yes. 18. Yes. 18.
Item 18, your lordships, I may be permitted to amend the cost title, your lordships. Because
Very please speak.
your lordships, the video, I think it is not able to start my video, your lordships.
What do you want?
Your lordships, I pray that to amend the cost title, your lordships, because this is Bank of Baroda. We have written without representing someone. We have written only Bank of Baroda.
No, you have written Bank of Baroda represented through its branch manager. You already Bidhan Chandra Sahu. There is no error in the.
Then your lordships may pass it over.
Yes.
Your lordships may pass it over.
Okay.
90.
May I please, my lords?
Yes, sir.
Here, my lords, the cognizance has been taken under section 275 capital B and section 275 capital BB of the Income Tax Act, my lords. Yes. And the delay in depositing of the TDS amount was 1 to 84 days, my lords. And this happened, my lord, during the financial year, my lords, 21-22, as at the peak of COVID second phase, my lords. The lordship have taken cognizance of these matters. 2 of your lordship's decisions and 1 of this honorable court, where the SLP has been dismissed, taking over the COVID grounds. And your lord, the delay was also.
You have explained the delay?
I've explained the delay, my lords. I've explained the delay regarding COVID at paragraph 6.4, page 9. My lords.
Page 9.
Page 9. I've said about the government's
page 9 of your petition.
Page 9 of my petition at paragraph 6.4.
Okay. What do you say?
No,
the COVID thing and covered by the judgment of. Sorry?
If permit, I will take instructions from the department, otherwise.
No, in the first case also.
I put it on Monday then. For obvious reason, you must appreciate that. I'll put it on Monday. It's covered case for you. For your sake, I'm just putting it on Monday. I'll allow it on Monday. For obvious reason, he must.
Supreme Court SLP dismissal.
Yes, sir, I understand. I know that. My judgment is in appeal now. Appeal in the sense SLP dismissed.
Right.
Not exactly appeal.
So far as
yes.
SLP dismissed.
SLP dismissed.
Okay.
Monday.
Thank you, sir.
See, the connected matter is fixed to 5th of.
I'm not aware of the connected matter. Maybe that there the judgment must have been.
Let it be Monday. This is the COVID case.
COVID case, ma'am.
So let it be Monday. Okay.
Lordship may just keep those judgments on the.
Yes, hard copy.
Hard copy. I've given
petition. Hard copy. I'll give it to him. Monday, please.
Yes.
Yes. Monday. I'll just issue notice then. Otherwise, it will be no use. Issue notice. Also access notice. Agreement to get the instruction. Leave the matter on. Yes.
20.
Make it Tuesday. Let it be Tuesday. Because you won't be getting at least 1 working day.
Yes, sir.
Make it, I'm making it Tuesday.
I'm not-
You should get at least one working day.
I'm not pressing my interim order today because your lordships have already.
Tuesday.
Man.
Yes.
20.
My please, Lordship. Petitioner seeking quashing of the FIR as well as initiation of criminal proceeding in Debugar PS case number 161 of 2023 for the offense 376 2N 294 323 506 and 34. My lord, the petitioner and the informant is an adult, aged about 23 years, and they were in a love relationship on the pretext of marriage. There was a relationship between them, and then they could not marry. And after that, the affair was lost. And my lord, in the medical examination report, there is no such no such result regarding the physical assault. My lord, may kindly see the page number 42 of the medical examination report.
Yes.
In point number 1,
You want passing on merits.
my lord.
How can I go into all these things?
My lord, at least if not.
Settle, I can understand, but I can't go into, I can't appreciate everything at this stage. Charge sheet has been filed.
My lord, charge sheet has been filed.
Then how can I appreciate the 161 statement, evidence and everything? And
164 may be called for and
why should I entertain at this stage? If you have settled the dispute, I can understand. But how can I appreciate the evidence collected by the police and pronounce whether you are
But my
guilty
lord,
or not?
medical examination report is
Maybe
clearly says, my
We don't know what will happen in the cross examination.
that she has not stated anything in her 164 that
You may be convicted for 376. Maybe for other offense you may be convicted. I don't know. I can't appreciate today.
Lord, at least issue may be noticed to her.
No.
Notice may be issued.
You argue, you can very well argue this thing at the stage of framing of charges, saying that this charge is made out, this charge is not made out.
My lord, on
That
the
is,
same,
that liberty I'll give. You move up this.
my lord, in the same affair, she implicated the father of the petitioner, and that is pending before my lordship. That may be tagged up.
No, you argue all these things before the trial court. Father's story is different. 376 and just see the charge sheet.
My lord.
376 2N,
Yes, my lord.
294, 323, 506, 34. Everything is there. Unless you make out a case that no, from the face of the record, if no case is made out, then I don't think you are settling the dispute.
The allegation about pregnancy, there is no such in the
You are
medical.
showing the medical report, there
My
is no physical assault and all.
My
And you yourself say that he promised to marry. It must be consensual. It must be consensual.
My lord,
And how will
relationship
you get bodily injury in a consensual relationship?
But there is no sign of recent intercourse.
That's right, consensual. That is the case. That is the case of the prosecution also.
My lord.
That's the case of the prosecution also. You obtain the consent by promise of marriage. So these are the things you have to try out. Petitioner is seeking quashing of the entire criminal prosecution arising out of the FIR number Dabuga PS case number 161 of 2023. After investigation, charge sheet has been filed in the present case on 17/10/2023 for alleged commission of offences punishable under section 376 2N 294 323 506 34 IPC. Relying upon the medical evidence for the medical evidence. Medical evidence, and counsel for the petition submits that the medical report reveals that there is no external physical injury sustained by the victim. Therefore, it is apparent that there is no forceful sexual intercourse committed by the petitioner. Hence, the case for the prosecution cannot be believed. Apart from that, she submitted that on the promise of marriage, the petitioner has alleged to have kept the physical relationship with the victim. Therefore, it is a case of consensual sexual interaction, sexual intercourse, and the offense under section 376 is not made out. I am not inclined to go into the merits of the case at this stage. Since the charge sheet has been filed, the petitioner is given liberty to raise all the points at the appropriate stage before the trial court. So, appropriate to this liberty, the petition is disposed of. Yes.
21. May permit to submit Mr. Ramachandra. My lord, here is the petitions challenge the cognizance order by the annexure 6.
Yes.
My lord, here is offense under section 341, 323, 294, 379, 506, 34 IPC.
Yes.
So far as 379 is concerned, there is allegation that initially the petition filed in 1/6 case. In 1/6 case, cognizance has been taken, and that is under challenge.
Yes.
So far as the allegation is that the petitioners taken out the paddy from the land of the complainant, who is added as opposite number 2, my lord.
Yes.
And so far that land is concerned, the scheduled land, he has mentioned that is the khasra number 155.
Yes.
That is complaint petition number 10, second paragraph.
Yes.
And I have annexed the annexure 3. My lord, can you give a glance to annexure 3? That is one land which is recorded in the name of a government, that is Abhajogi Anavadi. So far as plot is concerned, that is second page, that is page 18. Last plot, that is 155. Sharada Ege, that is recorded in the Anavadi Khata. And we, the persons, the petitioner 1, also taken the lease case and cultivating that land. When they go to harvest the paddy, there was a dispute. He is saying that, the complainant is saying that the so far opposite part number 2, that land belongs to me. Admittedly, the land not belongs to him. That is government land. We have taken lease.
He must be claiming that land belongs to him. You must be.
I am showing the document.
But document. Quarrel took place. Come to the initial statement.
My lord, initial statement, that is the same thing. That the persons came to my paddy field and forcibly taken away the paddy and threatened to me kill and tried to assault. Not assault, tried to assault. That is that. And I am showing the documents. So the land is concerned, we have taken in lease. That part should be taken into consideration at the time of taking of cognizance, because Huleka is there.
Allegation against you in the complaint as well as the initial statement is clearly made out. What can be done?
No, my lord, that is
I can't go into this ROR and say,
my lord,
you are the owner of that land.
My lord, kindly give a glance to paragraph.
Your whole case is that the land belongs to you.
Yes, my lord.
You are saying up an ROR.
ROR.
So therefore there are
no, I have no ROR. ROR in the name of government. I have taken lease.
Okay, government land. That is what. And that's the worst. That's the worst for you.
That is incident occurred in the paddy field. Main allegation is I have taken the petitions have taken the paddy. So far as 379 is concerned. And so far assault and etc. is concerned, that may be exaggerated. Because in the
maybe you say maybe it has to be decided.
Yes, he will come here. Ultimately, he will submit a number of documents that why I will face the trial. That is there. A number of persons.
That's one question. Why you?
I have taken the lease.
But at the same time, why should I go into all this thing?
For secular ends of justice
is made out.
Secular ends of justice. And so far as the judicial time is killing, I will face the trouble. I have taken the lease.
Why don't you see? These are the villages. Why don't you settle the dispute?
Yes, my lord may issue notice. Ultimately, that may be settled.
Here is a case arising out of complaint case, Your Lordship. OP2 is the complaint, here is the
No,
party.
see, allegations are very minor.
Yes, I have only 379 is concerned.
And see what happened, what I think what might have happened is, it's the comment length, both of them are trying to.
Already, Your Lordship, kindly glance, form core notice has been issued.
Let us issue notice,
Yes, Lord.
anything can we work.
Yes,
I'm simply issuing notice, ring him, if possible, we will settle.
My lord, issue notice.
Yes, I'll issue.
IA is there, not to take in course. I am not praying for a stay of the proceeding.
I am very reluctantly issuing notice. I'll take it after 1 week, I'll take it up. Take out the notice and try and bring him. Yes.
If you proceeding will
merit, you don't have a case, but
so far merit is concerned, my lord.
No, you don't have a case.
I will discuss that.
You are relying upon many documents.
Again,
can I, in a cognizant stage, can I rely upon the document which are not part of the charge sheet and decide it?
No, my lord. So far, no, here is not charge sheet, my lord. Here is a complaint case.
No, whatever. Which is not part of the form.
The complainant has to substantiate his statement.
Yes, substantiate.
Not substantiate, not file any document. The court has not taken.
Will you be happy with the notice or you want to do it?
I will file a time petition that will consider.
File the process. Yes, next.
22.
I will file a time petition that will consider. If time will start.
Take out the notice first. Yes. Ma'am, please. Here the petitioner says to challenge the non-compliance of the DNA test. The affair has lost after 7 months. The occurrence of the test. Lordship is down to Annexure 1. Annexure 1. Yes. The affair. Yes. Here the occurrence was said to be of 5/1/2022 and the affair has lost on 5/1/23. Yes. And allegation that the petitioner has some physical relation with the victim. The informant, the elder sister, has noticed the same, and in which charge sheet was framed and charge was framed. Charge sheet submitted, charge framed, and no DNA test was conducted. 376. No DNA test was conducted. The petitioner claims he is not the author of the crime. Not necessary. You will be acquitted. That's not the requirement. It is the prerogative of the prosecution whether they conduct. That is the judgment of this court. But in every 376 case, DNA has to be done. If there is a child. No, the victim is dead and dumb. That is therefore more of a reason that I shouldn't interfere. Victim is a deaf and dumb at 376. And I will not. The sister of the victim has lost the affair. No. A deaf and dumb girl and 376 2N. What is 376?
It's 376 2IN 417 506 360.
The allegations are all false. False or not
victim is deep and dumb, Your Lordship. After killing 7 years pregnancy, that
concept petitioner seeks to withdraw the present petition to raise all the points before the court below at appropriate stage with this liberty petition is disposed. Yes. Next.
23.
I believe, Your Lordship.
Yes. Yes, sir.
At this stage, instead of going to the merit of the case, I have challenged the order of cognizance before Your Lordship. 3 SCST is there. So, for the better adjudication, notice is to be issued to the opposite party number 2 with the victim informant in the case, and thereafter the matter will be taken up. I will say the legally taking cognizance under Section 3 SCST Act is not tenable. That is the point. That is a question of law. And the law provides that the victim is to be heard at any stage. So notice we simply issued.
Yes, Lord,
notice to opposite party number 2. Mr. Manti, 11 ACA.
Opposite party number 2.
Yes.
Opposite party number 2.
Yes. I issued. Yes.
24.
Yes, sir.
This matter relating to a DA case matter. Both husband and wife are cited as an accused, and all the accounts of both the parties have been seized. The petitioners have filed this application to defreeze some of the account on the ground that the money which was defreezed was come from the GPF drawn, my lord.
Yes, Mr. Marana.
Please kindly have a
examine it. I'm just issuing it. Let me examine.
Already done. That is document says that it is GPF account. It has been transferred to the wife account. That is admitted. That respect with my objection, your lordship allow. So, and second part is concerned. That is defreeze of gold ornaments in the locker with condition that may be defreezed. He will not sell it and he will produce the larger. Since 7 years, the investigation not completed. May not be. That is another aspect.
That's another aspect. Show me your application.
My lord. He made an application before trial court for defreezing of so many accounts. Now he has confined it to one account.
Where is that?
Place
where will I get that?
Page 22, my lord.
22.
My lord.
Okay. Yes.
Part final withdrawn from the GPF account number TRACK approximately Amresh Kumar Patra, RTO, Babaleswar, my lord.
Yes.
Then, my lord.
10 lakh rupees. Which has come from GPF.
GPF, my lord. Then it is page 27, bill has been
and
passed.
Amount withdrawn does not. And what else?
Then, my lord, page 27, the bill has been passed by the office.
No, he is agreeing that.
My lord.
GPF, I'm not on GPF. And what else you want?
That
GPF?
Gold and silver. Ornament in the locker number. The locker has been seized, which belongs to the wife.
Show me which are the two things which you want release. One is the account, which is he is agreeing to that the money has come from GPF. That I'll release, no problem. Defreeze. And what about the other?
The gold ornaments which was kept in the lockers, my lord, that belongs to the wife and NID.
Show me that. Wherever you say that, that's what I want. Para? 3 of
the petition. Petition, my lord. Prayer. Page 5. Page 8, na? Page 5.
Page 5, huh? No. Para 3. Para?
Paragraph 3, last question. Last question.
The gold ornament lying in the locker. The bank charging locker fee so similarly money lies in so to be stands in the name of 2 where 10 lakh rupees funds transfer from the account of so bank locker number
34. 34 Indian Bank Tulsipur branch 34. Prayer.
Where is that? Prayer.
Page 8, my lord.
Prayer. Yes, what is the security you want?
Condition that he will not dispose of the said ornaments and he will not change the nature and character of the ornaments and he will produce the same as and when required for the purpose of investigation and trial.
Right. Petitioner is agreed by where is that order for the trial court rejecting your prayer?
Page 31.
Petitioner is agreed by the order dated 12/9/2023 passed by learned Special Judge Vigilance Cuttack in criminal MC number 11 of 2023, whereby the application of the petitioner under section 457 CRPC for defreezing the account, which is that savings bank account number 3043917555055 in the State Bank of India, Bidanasi branch, Cuttack, which is in the name of the petitioner number 2, has been rejected. Apart from the prayer of the petitioner for release of the gold and ornaments lying in the locker number 32.
34.
Locker number 34 in the Indian Bank, Tulsipur branch, Cuttack, which stands in the name of the daughter of the petitioner, has also.
No, it is a joint name of both the petitioners.
Joint name of the both, joint name of the petitioner has been turned out. turned down. Heard Mr. So-and-so and Mr. So-and-so for Mr. Maharana, Lieutenant Counsel for the Vigilance has submitted that the investigation in the present case is still going on. Therefore, at this stage, releasing of at this stage, the investigating agency may require may require these two seized account and locker for the purpose of investigation at this stage. On the contrary, the counsel for the petitioner submits that is ready and willing to give undertaking before this court that as and when the investigating agency is required to produce the ornament, he would make it available to the available for the purpose of investigation. Insofar as the savings bank account maintained in the State Bank of India is concerned, it is apparent from the record that where have you shown me? A record that the 10 lakh rupees which is lying in that account was transferred from the GPF account of the petitioner number 1. GPF account number, account number TR bracket 0 1494 of the petitioner number 2. Since the amount lying in the savings bank account maintained by petitioner number 2 is admittedly transferred from GPF account, so I am of the considered view that the savings bank account is liable to be defrauded.
To the tune of rupees 10 lakhs in respect of GPF, all money in mind.
To the extent of 10 lakhs. 10 lakhs. Accordingly, the trial court is directed. Accordingly, the investigating officer is directed to take necessary steps to intimate the State Bank of
the concerned bank
for release of defreeze of the account to the extent of 10 lakhs. 10 lakhs. Insofar as the gold ornament lying in the locker number 32 of Indian Bank is 34 in Indian Bank is concerned, petitioner is directed to furnish the particulars of the IO is directed to prepare an inventory of the gold ornament, and the petitioner is directed to furnish an undertaking before the IO that he will neither change the change
the nature and character of
neither change the nature and character of the gold ornament nor
dispose
sell the same. Dispose of the same.
And make available as
dispose of the same. At the same time, petitioners are also furnish an undertaking before the IO that as and when required, the gold ornament shall be produced before the IO or before the court as per the requirement. With these conditions, the locker both the savings bank account and the locker shall be with these condition, the IO is directed to intimate the bankers of the petitioner along with this order. Yes.
Master, time may be fixed to approve the order.
The same may be done within 15 days.
2 weeks.
Within 15 days.
25. 3 copy.
May I please? My lord, this is a bail jump case.
No, bail jump not open. Lordship, kindly see page 16.
16?
Page 14.
Okay.
NBW, after NBW, Dishonorable court directed the petitioner to comply with some condition to appear and release. Then your lordship turned to, did not comply. Then he turned to, then 16. Page 16, he approved dishonorable court for modification of condition and extension of time. That was not, that was rejected by dishonorable court. Then again in page 17. Again he approved this court extension of time, that was also dishonorable court not. This is just
now the trial has been started, sir.
For 8 years,
trial is stuck now. What to do?
No, your lordship may allow him to surrender and get him released with the condition earlier granted by dishonorable.
I'll not say anything. Resort to the remedy available to him under. I'll not say anything. Why should I get into all this? Then if I'll get into all this thing, I'll have to reject it. If it reject, then your trial is stuck. Trial is stuck. He is volunteering to appear. Let him do whatever.
For 7 to 8 years, sir, he has attended all the dates. Only one
there is some condition imposed by this court. You have to comply that condition.
Sir, during that COVID-19, sir, he had gone to his village for which he could not be communicated.
Whatever, see, you surrender, then your bail application will be rejected. Rejected unless you comply the order. Yes, right.
So he may be allowed to surrender and release.
Yes, petitioner is agreed by the order. Dated. Which order, sir?
Order
NBW order.
NBW dated
7119.
17/1/2019.
Right. Petitioner is agreed by the order dated
17/1/2019.
Whereby NBW has been issued against the petitioner by the additional special judge vigilance Bhubaneswar in the trial. What is the case? In the TR case number 23 of 2011. The petitioner was earlier enlarged on bail by the court with a certain condition. The condition has not been complied. It appears the condition has not been complied by the petitioner. Rather, he sought extension of time before this court repeatedly, which was not acceded to. The petitioner remained absent from the trial court, leading to the issuance of NBW. On instruction, the responsible for the petitioner submits that his client would appear before the court on or before 15th of December and resort to the remedy available to him under law. Regarding to the statement made at the bar by the land counsel for the petitioner, the NBW issued by the court below by the order dated 17/1/2000. Execution of NBW issued by the court below by the order dated 17/1/2019 shall be kept in abeyance till 15th of December 2024. Subject to condition that the petitioner shall appear before the court on or before the said date and resort to the remedy available to him under law. With this observation, the petitioner.
That judgment I have gone through and it's covered.
I know you
I'm mad.
also dictated there. You have underlined this thing.
Until relevant portion, that guideline is covered by that. Region order.
Yes.
26.
My lord, kindly pass over the matter.
27.
Yes.
Pardon, Malsi, one humble prayer, Malsi. Item 29 pass over, Malsi. 29 item.
What is this matter?
I am 27. I am for 27.
Well, I'm humble. I am.
27 is going on, but 29 you ask me for a pass.
Well, I apologize. Pardon.
Wait, have patience.
I'll arguments.
You are in hurry?
No, I'm hurry. I was in court number. Another case is there. Well,
unless you have the urgency of nature calling you, then there is no urgency. Wait for two minutes. I'll take it off. Yes.
My lord. Here, my lord, petitioner challenged the criminal proceeding initiated against the petitioner. Here, my lord, informant is the father and petitioner is the youngest son. FIR was lodged on 4/1/23 against the petitioner under section 307 and 328 of IPC. My lord,
the accused is the son.
My lord, around 1 year and 10 months have been passed. Police have not come.
All right, but 307,
You know, my lord.
you attack your father.
No, fact, no, ticket, Fact is that, my lord. So, my lord, now the matter has been solved between the father and son. Already solved, they have compromised. My lord, family dispute have been they settled between
Right, but investigation is going on.
No, my lord, charge sheet has already. No, have not been, charge sheet has not, charge sheet has not been submitted.
Except FIR, you have not filed anything. How will I know?
No, charge sheet not have been submitted yet.
Let the charge sheet come.
My lord, notice may go to the father. No, I have completed.
See, I'll tell you. You have done something to your father.
No.
You have given poison, whatever. You are saying that you have settled. Bring your father along with you.
My lord,
I will not be a party to that.
I will bring my father along with
whatever you do. I'll simply adjourn it. Mr. Vishal, give me the charge sheet. I'm just simply adjourning after 2.
No, short date maybe I will bring my father with me.
Short date only. I'll give a short date.
Yes.
And get the charge sheet copy.
Yes. Charge sheet.
See, I'll tell you, if the allegation is he was the son.
Poison in the water bottle of the elder brother.
Elder brother drinking.
What kind of son you are? What kind of son you are creating problem for the family?
No, option it is a but
let us see the medical evidence.
All these things.
Medical evidence and anything is found. If anything is found, then what are you doing, by the way?
I'm just a businessman, my lord.
What business?
Pan shop in the village. Panodoka. Little shop.
If you impose cost also, you can't pay. It's another problem. Anyway, let us see the charge sheet. Okay.
I will bring my father.
1 week. Reach it after 1. Bring your father at
least. Yes, madam.
Yes.
29.
29 may I please? I only pass over my lord. I'll take up. Oblige.
May I please? Quashing of proceeding, my lord. The complaint case arising under 130 NI Act, my lord. The basis of complaint case filed, my lord, page 19, annexure 3, to check.
19?
Page 19, annexure 3, my lord.
Yes.
This account number and there is valid for rupees 10 lakhs and under, my lord. For complainant in complaint case.
Sorry?
30.
This is 12 lakhs.
12 lakhs, but
Yes.
valid for 10 lakhs and under, my lord. But somehow the employer managed to took out check and fill it to 12 lakhs. And the Cognizance taking and
whose signature is this? Servicer.
Service is my signature.
Then?
But she took the signature and fill it. This is my check is on valid for 10 lakhs. But it's 12 lakhs. It's an invalid check, my lord.
That is what I'm saying. Why have you given them?
I am not giving, my lord.
Then you signed it.
My signed check is there, but somehow he managed to took away.
How?
Both related, my lord, there is business transaction.
What can I do? And you have signed the check and given it.
What is the invalid check, my lord? And now
that is what the delegation is.
Yes.
You have issued an invalid check.
No.
How much you owe? How much? What is the amount you owe to
that? Allegation is 12 lakhs, my lord.
Forget about delegation. What according to you?
That's no, man. Nothing, my lord.
Nothing. I can't help you.
And lordship kindly see now. The director me to deposit my 10% of that amount, my lord.
I can't help you because see,
yes,
check is admitted.
Signature
check. It is only valid up to valid for 10 lakh. It's all right, but you have issued 12 lakh. And show me the reply to your notice. Have you said that in the reply? Where is the reply? Friendly loan. Yes, notice was issued to you on 9/5/2022.
Mail.
Oh, have you replied to that?
But that show the notice mail.
No, statutory notice under 138 NI.
That is not, let it come next week, my lord.
That's the minimum, sir. In the 138 NI Act, the statutory notice is issued to you.
Yes, ma'am.
Have you said that?
Tuesday, let it come Tuesday.
Then
Tuesday, my lord. Tuesday.
file this kind of petition, what to do? I can't help you.
And Tuesday.
Please sit next week. You don't have a case. Absolutely no case. I'm just on your request, I'm putting it next week, but you don't have a case. Yes.
31.
Bring that reply to the statutory notice which you have. Yes.
Next Tuesday.
No, please, your lordship.
Yes.
Here I am challenging the order taking cognizance.
Yes.
Under section 385, that is annexure 3, my lord. Your lordship will find at page 34. Cognizance has been taken under sections 385, 387, 34 of the Indian Penal Code, read with section 25 1B and 27 1 of the Arms Act.
Yes.
My lord, my ground of challenge is twofold, my lord.
Yes.
The first of all, your lordship, this is a very interesting case, my lord. The FIR has not been lodged by any of the victim, my lord, alleged victim. My lord, the allegation here, my lord, as per the prosecution case, the INC of the police station, concerned police station, he was going by his vehicle, my lord, and he found on the road a piece of a broken piece of a vehicle was lying and a number plate was lying. So he inquired on the spot. Some of the, as per the allegation, some of the nearby people, they say that a group of people, they were coming and for the purpose of extortion, and on the particular day, they tried to extort from a truck, and since he didn't pay anything, my lord, they dashed their vehicle against the truck, as a result of which their vehicle was broken. That is the one of the allegation on the basis of which, my lord, the prosecution has been instituted by registering the affair, my lord. My lord, your lordship will find during such my lord, investigation, my lord, prosecution has not even tried to trace out the victims, my lord. None of the victims have been traced out. None of the victims have stated anything, my lord. And some of the statements have been recorded that they heard that this thing is going on. On the basis of that, the prosecution has been instituted.
Victims are not identified.
The victims are not identified. Prosecution has also not taken any interest to trace out the victims. Simply on the basis of some of the villagers, my lord, that they heard that, my lord, the hearsay witnesses, my lord, the prosecution has been, my lord, and the charge sheet has been submitted.
How will you prove your case?
Now here except this petitioner is declared absconder.
That will deal with that. But you don't have identified the victims. You don't have identified the vehicle. Even if they are put to trial, how will you bring home the charges?
That is the question.
Charge sheet, the page 29. Page 20.
Have you identified the victims?
They have no, they have not identified.
I don't think. What will you do? Subjecting them to prosecution. Somebody should be the victim.
Yes,
and very interestingly, your lordship will also find that the Tata Safari vehicle, which was in a broken state, that was seized from another person who is not accused here, my lord. And his statement is also not recorded.
Examine it. So, if it will be that exercise, then I will interfere. Because Gyan Singh says that if you know at the threshold, you know that nothing is going to be achieved out of the trial. and you can't perhaps get a conviction out of these kind of facts, then the court can interfere at this stage. Just examine it. I just issue notice to us. Yes. Yes.
Your Lordship, I have filed one interim application.
What will happen?
Arrest for the
Charge sheet has been filed. You move over.
No course of action. Set up move करे आप पूरे surrender करी move करे से reject कर देवे.
What are these are the offences, small offences. Who is
Reject कर देवे सेठी.
Who is going to?
385 is the allegation, my lord. So straightway they'll reject, my lord. Your Lordship may direct no course of action till then, my lord. Your Lordship is examining, my lord. This is the situation, and 25 1B also without sanction cannot be prosecuted, my lord.
What I'll say is, I will protect you for some time. You go and apply for bail. I can't do that. This is no. I will protect you. I will protect you for some time, but you go and I will bail. That's
reject the,
see, this is the wrong way of doing it. In a 482, you don't resort to.
But when there is absolutely no material.
No, there is no absolutely no material. This is one thing is appealing in the sense that the victim is not identified. Yes. I'll examine. He is also going to examine it. I issue notice, no problem. I'll protect you for some time. You go and resort to the remedy. I'll protect you for some time.
Your Lordship may say that you will maintain clarity.
Release the matter on December first week of December. Where is December? On 20th December. Release the matter on 20th December. Till then, no coercive action shall be taken against the petitioner, subject to condition that the petitioner shall appear under before the court by that date and resort to the remedy available.
So parity maintained per dispute.
And it is liberty is also granted to the petitioner to take all the grounds for bail, including the ground of parity. That much I can do. Not beyond that, because
that is
the jurisdiction of another court and do that.
It is very well known that it cannot, no conviction can ever be held.
Maybe in between you apply for bail. Yes.
No pleasure.
I'll just come. I'll just 5 minutes.
The cases that both the party married and
married on this is ground, but it's again settlement.
Yes,
it is settlement.
Oh, settlement.
Show me, see the judgment if you can distribute your case.
I'm appealing for the how do you?
Can you distribute your case?
This thing is not
referring that judgment.
And
that's right, but now
in the last para also, the preliminary para minor, Apex court has observed that the chances of conviction is bleak.
In which case you are talking about?
That last case,
show me that part. Show me.
that's
the problem. You show me which paragraph will help you. I'm ready to do it. I'll take it up 2 o'clock. Just go through the judgment. Help because there are many cases which are coming.
Okay.
These are the your case is directly covered by my judgment. There is no doubt about it.
Yes, madam.
The problem is I have been allowing it. But for this judgment, I am holding my hands.
And in this judgment, madam, 1 minute, madam, the compromise was held with the father of the victim, not with the victim.
Read the judgment, the tenor of judgment.
Okay.
Because it will be helpful for others also. I'm not in this case. No doubt, it will help you. And please read it. I'll take it up 2 o'clock. Give the judgment and let him read.
Similar case
And get a photocopy for me also. Yes.
48.
48.
Okay, so 307, the compromise.
Yes.
Settle between all that present blood to the petitioners, the injured and the informant.
Show me the injury report.
Yeah. On record, please. On record.
What is that?
The memo which was filed on 20th.
Where is the injury report?
Injury report by way of memorandum, I have filed the on 20th 11. Petition.
That's
Let's see.
Yes, show me. What does it say? Have you read the file or not?
Opinion, the scalp avulsion injury. The reply will the below.
You must read the file before coming to the court. Not that you start reading here from A to
Yes,
Z.
scalp avulsion injury, which I said not mentioned.
Take it up at 2 o'clock. Yes. Next.
What?
32.
32. Please read the file properly and come.
Yes, that is the.
No, you have not read it.
Yes.
You have not read it. Please read it. Yes. At 2 o'clock I will take it up. Okay.
This is also.
How to deal with it?
Both are major.
Now they become major. No?
No, at the time of affair, she was major.
How
She is saying
16.
I was that time 16, so they had relationship.
But now charge sheet.
Till then, at least.
No. You bring
No,
it. I know. Pass it, I'm saying I'm
No,
pass it.
that's true, bro. That's true.
Till Monday, what will happen? Once interim order is given, then you will be. No, Monday you come, I'll quash it. Because age is 22, I've seen it.
Yes.
Yeah. I'll quash it.
Kindly pass over.
Pass over. Don't ask adjournment on that day. Yes.
35.
At least.
35 also.
Pokso manner. But charge sheet submitted 366, 370.
Where is the charge sheet?
Page number 25, annex 4.
25. Yes. Yes.
Manner. 6 is there, man.
6 is there.
6 is there. But out of the court manner, they both the family members settled their matter. And in between, the victim girl married to another boy. And she doesn't want to.
I know it, all this thing. Why are you telling all this thing? How will you get out of this judgment? You tell me. Routinely, I was doing all this thing. You come at 2 o'clock. Mr. Tripathi is preparing for.
No.
If I can distinguish the judgment, I'll help you. And you must read the judgment and tell me.
Madam, I will read.
Usual story you are telling me. You read the judgment, you find out ways and help me so that I can pass an order in your favor. Yes.
36.
The application on certain particularly age, the ground given your oxygen.
Sir, please use mic. I can't hear. Yes, sir. Yes, sir.
It's a NI Act proceeding. After appearance of the accused and after framing of charge, when it is fixed up for hearing, an application on 143A was filed for interim compensation. That was rejected on the ground.
You are the complainant. Yes. What is the ground?
Had both sides and perused the case record and connecting documents, page 20, madam, paragraph 4.
Yes.
Added with a view to address the issue of undue delay in final resolution of the cases relating to disjournal of check, to provide interim relief to the holder of the check, as well as to discourage unnecessary litigation. In the instant case, madam, this is the finding he has given. But now I am placing a lawsuit to the statute
Yes.
It specifically speaks of 143A1A. In a summary trial or summons case where he pleads not guilty to accusation made in the complaint and in any other case of framing of charge. This is the situation when the application can be moved.
Okay, I'll issue notice. Issue notice to opposite party. Yes.
37.
Madam, kindly pass over.
38. May I please?
Yes, sir.
Order 19/9/2024, page 12, the challenge mallet. Only grievance mallet I have given it is the for the posted for defense evidence mallet.
Sorry,
the matter was posted for defense evidence mallet. But on that both the complainant and as well accused appear, both counsellors appear, and the this and the Hon'Ble Court was pleased to close the defense evidence matter. Only my friend, I will give one defense evidence, that much.
Where is that order?
Order page 12. Order dated 19/9/24.
19.
First
Non-NDPS for the present party, the court reported to the class with no state to the defense counsel on evidence. Defense is made by court.
One evidence.
This is the
130 NI Act.
Pending since 2020. I think we should allow it. Petition is agreed by the order dated 19/9/2024, passed by the JMFC bracket CT Kyonger in ICC 1CC case 1CC bracket NI Act case number 37 of 2022, whereby the defense evidence supposed to be led by the petitioner was closed.
Petitioner stroke accused.
Huh?
Petitioner stroke accused.
Petitioner oblique accused has been closed. Right. The on 19 on 19 the impugn order is said for page 12. And consequently, the petitioner submits that when the impugn order was passed closing the defense evidence, that day neither the complainant nor the petitioner nor the accused petitioner appeared before the court. Therefore, the court ought to have afforded opportunity to the petitioner to lead defense evidence. However, the defense evidence has been closed and the matter is put up for final disposal on 27/9/2024. Matter is still pending.
Still for argument.
He further submits that the matter has not yet been concluded. And the matter concluded, and the trial court has set the trial. Set the matter for our final disposal.
For argument.
Final argument. He further submits that one opportunity may be afforded to the petitioner for
defense
for leading defense evidence. Different evidence. Regarding head to the aforementioned and the statement of the counsel in the bar, I'm inclined to allow the petition, directing the trial court to afford a singular opportunity to the petitioner to conclude his defense evidence. The JMFC CT Kyonger is directed to fix a particular date and afford an opportunity to the petitioner accused to lead his evidence in defense without seeking any further adjournment. With this observation, petition is allowed. Yes.
Oh, blessed.
39.
Passing of criminal proceeding under the ground of compromise, my lord. The initially the FIR is registered under section.
Charge sheet filed.
Charge sheet filed, my lord.
Filed. Show me the charge sheet. Show me the charge sheet.
My lord, today I received the copy, I will file the court.
Show me the charge sheet. What are the offences? No, we can't be done the same story. Section 6,
Well,
376. Nothing can be done. Nothing can be done.
my lord, both parties are married.
Don't tell all the story once again. This is the fifth matter I am hearing. Have you read the judgment, recent judgment? Without reading, you are coming. Have you read the recent judgment of Supreme Court? You don't prepare the case and you are coming and arguing the same story. Please read the judgment of Supreme Court. I know that my judgment, you are covered by my judgment. But there is a contrary judgment of Supreme Court. Just 15 days back.
My lord.
Take the citation and read. I will take it up 2 o'clock. 3 matters I have kept it 2 o'clock. I will pass a common order and dispose it up. Yes.
May I please, your lordship? May I please, your lordship? In this case, the direction for release of the seized vehicle, which was seized by the Bosta police station opposite party number 2 for commission of offence under section 7 of the EC Act. My lord, kindly have a glance at running page 27.
47.
27, annexure 6.
47.
27.
27, okay.
Yes.
Yes. Yes.
Commissioner has filed a petition for release of the vehicle before the Land Jam FC Bosta. But the Land Jam FC has not disposed of this matter. During the pendency of this case, the Land Jam FC has been pleased to call for the report from the opposite party number 2. The opposite party number 2 has not intentionally submitted the report. Till today, this vehicle is pending before the police station.
Yes.
My humble prayer is that the direction may be given to release the vehicle of the petitioner.
What is the direction? Ultimate direction? 14.5. 14.5. There is the application is not allowed.
Yes, my lord, the application is pending by the Land Jam FC. Till yet, the application has not been disposed of.
Then I will simply say that let the application be disposed of. That's all.
With the observation made in the Supreme Court, which is reported in the Sundar.
Try to appreciate if the order is passed this way or that way.
Yes.
By the magistrate, then a revision lies against that.
Yes, my lord. It's because
then your grievance is the application is pending. It is not decided. I'll just direct the trial court to decide your application as expeditiously as possible.
Yes, my lord. The specific period.
Order dated 14/5/2024, whereby the trial court has adjourned the application, adjourned the hearing of application moved by the petitioner under section 457 CRPC, seeking release of the pickup van.
Pickup van
bearing number OR-01T-5181. 5181. Land Council for the petitioner submits that despite when have you moved the application? Where is the application? Yes.
Yes, the application I have filed.
Let's move the application. 14/5/2024. The trial court, although has called for the report, but has not decided the application. Hence, he is aggrieved. Regarding head to the statement made at the bar, I'm inclined to direct the Lieutenant JMFC Bosta to dispose of the application under section 457 CRPC moved by the petitioner as expediently as possible, preferably within a period of 1 week. Yes.
1 week, my lord.
Yes.
41 is double edge.
that usual matrimonial supply of document papers, all the documents they are not supplied. Last time the lawyer was posed the question that you tell me how many pages are there.
Yes.
That instructional letter, your lordship may dispose of with a direction that let him inspect and whatever relevant pages here it will be given.
That order of the mandate has passed. Why should I inspect my lord? This is the case. Under the case against.
Why you, I told you to, how many pages, give it, what? See, the High Court is engaged in this kind of business. 207 application also you don't.
Lordship may dispose.
Give all the, how many pages?
More than 3. 2 or more than 3,000.
Last time also more than, you started more than one.
It is better known to him.
I'll take my copy. They are not a Xerox copy.
You speak to the IO and tell me in the afternoon. See, suppose it is very voluminous. If I pass the order, and it will be very difficult.
My copy I'll take one. Because I have to prepare my.
I can't write all these things in the court order. I can't write that the accused would pay for getting the paper.
It is what has happened, my lord. I'll tell you. This is a case.
Why can't you tell me definitely what? Neither you are able to tell, none he is able to tell. What to do? I have to presume.
I have to obtain instruction from the lower court.
He started with 1,000 pages. Now he has reached to 3,000.
He has a document.
I can't pass this kind of order on the basis of presumption. Neither you are able to tell. Yes,
I take instruction, my lord. You are also making people next week.
How many at 3 o'clock you come? I'll dispose it up. Otherwise, I'll pass a no course order. This will be neither here nor there.
Monday grow, I'll check it.
You have converted this court to a police station. I'll start counting how many pages are there. I'll give.
Supply matter.
That's right, I understand. But the provision says inspection also. The trial court, I can't find fault with the High Court trial court order.
Magistrate has to be satisfied. That satisfaction has not.
How the magistrate? How will be the magistrate be satisfied? How do you say that he will not satisfied?
Suggestion of the may I read the order, madam?
I read it.
Madam.
According to me, he is satisfied. I simply say I'll dispose it up because you are not able to satisfy me. How many pages?
You'll also make.
He is not able to satisfy. Neither the prosecutor knows, nor the defense counsel knows how many pages. No, you tell me. I'll not keep this.
Monday.
No. 3 o'clock, Mr. Morana, you speak to the IO and tell me. This supply of pages and all these things.
I'm not well today, after lunch, Monday.
Your competent junior is very. First of all, you shouldn't come in this kind of. This is not a matter to your standard. You she will appear. I'll dispose it up. You need not be there, and he will get me instruction. How many pages you simply tell. Just speak to him. How many pages? And he will spend money to get it. Finish.
Yes.
If it is very huge volume, then I can understand.
These are all
1,000-2,000 pages.
These are all cash receipts, madam. What has happened, I'll tell you, madam. This is there is a provision in the Municipal Act that unless they return the cash book, they cannot get another money receipt. Here, money receipt has been issued, and it is allegation is that he has misappropriated the money without depositing that. Unless he deposits the money, he cannot get the receipt.
I know.
That is why, I want all the receipt. There is a signature in all those money receipts.
And you just ask him. Just ask him. I'll dispose it up. Don't worry. Yes. You may not come. Mr. Paul. Yes. Can you speak? Yes. Yes.
My lord, the matter has been settled between the husband and the wife. Offense under section 498, 290.
Now, where are they?
My lord.
Where are they? Have they come?
No, issue notice to.
If settling dispute means you have to bring them.
Certainly, she has received 25 lakhs.
Oh, so she doesn't want to come now.
Now, after notice, she will.
Okay, I'll issue notice. Written note, right? Yes.
44.
One.
Right.
In this case, the petitioner and the petitioner for passing of entire criminal proceeding. Yes. My lord, in page number 63. 63. Yes. I have submitted the order copy. Yes. Of Lorraine trial court where the court is clearly written in last line. Hence, in view of the mediation report and withdraw petition for petition is allowed. The case is reading. Page number 63, last two lines. Yes. Hence, in view of the mediation report and withdraw petition for petition is allowed, the case is disposed as reunion. Between both the parties, the union is made and they are living a happy conjugal life. And the offense under section 492 to 94. Okay. You call them? Right. See the accused. How many accused? Where are the accused and informant? Let them appear through VCI. The informant is giving birth of a child and speaking with her mother. It is civilian benefit. And the accused person is serving, and the second petitioner is the widow mother of the accused petitioner. Where is the mediation report? Do you have the mediation report? Madam, the mediation report is not submitted, but the order of Hon'Ble court is submitted. Show me the mediation report at least. My lord, give me some time to open the mediation report. Mediation report must be part of record. What is the terms of settlement? My lord? What are the terms of settlement? The settlement is made between the parties that till the delivery of the child, I think petitioner number 1 is paid 15,000 rupees per month, and after delivery and taking rest for 6 months, the informant into the house of the petitioner and stayed there. As per their settlement, where is the, at least you find that affidavit. Both the parties didn't say anything. They are not filed mediation report. How will I quash it like this? Affidavit at least. Information last delivery. Then you file the affidavit at least. My lord. Nothing is there on record. How can I quash it like this? I'll just simply adjourn it. I can't help you. That's the whole difficulty, because you are not helping your clients. Filing proper petition and I don't know what will you do. I will not. I'm not exercising advisory jurisdiction.
Your Lordship, just a single pointer, Your Lordship. In the FIR and 161 statement.
Forget about all these things. What had happened is there is a settlement. It was some proceeding was initiated and it was sent to mediation. In the mediation, they have settled. And the court says that in view of the mediation report, I am closing this proceeding. Mediation report is not there. What is the terms of mediation settlement? Nobody knows. No, there is no affidavit. There is no averment. Can I?
The husband
Very poor state of affairs. The petitions are filed very casually. Adjourn it for adjourn. Do whatever you want. Make some averment, make some affidavit. Tell me what are the terms of settlement. Well, I am submitting the settlement. But she is unable to present because the court to find the application. Not entitled to know at least what are the settlement. How will I write the order? Well, I am submitting the after 2 weeks. Yes. One advertisement. One adjournment. Yes, giving adjournment. Password?
56.
Yes, sir.
46, my lord. Here the petitioner is challenging the entire criminal proceeding initiated against him. On the ground that
the person, those who are arrested from the spot, they face trial. On their statement, my lord, this petitioner was implicated. Now those, that person, Anand Maji, my lord, will also glance to page
Yes.
91 under annexure 3 series.
Yes.
My lord, he faced the trial and acquitted. The learned court below has held that the evidence brought to the notice of this court so far is not clear and cogent, for which he was acquitted.
Yes.
Now, as the petitioner was implicated in the case under based on the confessional statement of co-accused person, it squarely covers the judgment rendered by your lordship in Rakesh Chandra Sahu case.
Yes. The copy out. Copy.
Those out of 85%. Where my lord says directed when the main accused, those who are acquitted in the meantime, will proceed against that.
The judgment will not help you because this judgment only says that chemical analysis report was not placed on record. Therefore, they were acquitted. Therefore, I say that since chemical analysis examination report is not placed on record in an NDPS case, and even if this petition is put to trial, what will happen? Nothing will happen. Because the co-accused persons were acquitted on the ground that chemical examination report is not placed on record. That was the ground for acquittal. So therefore, I said in that matter that since the co-accused persons are acquitted on the ground of lack of evidence in the sense of chemical.
In this case also, the evidence of the PW says that this is what the learned court below has held.
Anyway, what I'll do is I will.
Will also be called for the CD.
No. I will direct the trial court to conclude the trial within 3 months.
Only of these petitioners, my lord.
Yes, you appear because you have been absconding. You appear.
Split up. The trial was split up. Then
Split up, so he was absconding. So I'll simply say because he is bound to be acquitted, 100%.
Since he was absconded,
Will also be called for the CD. I will.
No. I will only see it within 3 months. You surrender, resort to the remedy under law, and within 3 months the trial court has to conclude. Simply, you will be acquitted. Why do you worry?
No.
Right now. Petitioner is seeking quashing of the FIR and the entire criminal prosecution initiated against him for alleged commission of offense.
Got the date not how whether they have produced the chemical report or not.
1 minute. You show me from the judgment.
So got the date how I will.
No. I read it. Read it. I will read with you. Let us read the entire acquittal order. If that chemical analysis examination report is not there on record, I'll be acquitted right now. Here. You read my judgment. You should have read this judgment also. This judgment and tell me that.
Next week.
I'm reading for you. No, I'm reading for you.
No.
Let us finish it. Unnecessary spending.
Chemical analysis report.
42 was not complied here, my lord. That was reflected in the judgment. And further, the also not complied with. Her change seizure was also not proved by the prosecution. Nothing about the chemical examination report, my lord. Journalist Jimmy attested to endorsement formal signature spot map for a person.
Exhibit, exhibit
Exhibit 11 by 13.
P22. Show me.
P22.
That's the examination report.
C report.
How it was placed on record.
It was not dealt with in the judgment.
If there is the report. So that judgment is out. That judgment of mine, you will not take benefit of that judgment. Each report is there.
That was in the exhibits C report.
Exhibit P22.
P22 C report. But that was not dealt
Can't
with.
be. You are not covered by that judgment. Give it to me, I'll pass the order. Yes. Yes, I'll pass the order.
Okay.
Yes, sir.
45. Subscribers loss.
Just pass over. Somebody asked for passover.
Oh, sorry.
Yes.
47.
That was not so. My lord, that matter is just out of the law of two adult persons, my lord. My lord, at the time of the affair, the victim was major, my lord. And now the victim is married somewhere else and she is blessed with the charge sheet, my lord. Annexure 2, my lord.
You have settled
Yes,
the
my-
issue then.
My lord.
Call him.
My lord, let it come on Monday and we'll call all the parties.
She married somewhere else.
My lord?
She has married somewhere else or she is married
somewhere else, my lord.
What are the allegations? What are the allegations? Let us see.
My lord, I'm reading the affair, my lord.
Yes.
Mood Asmita sir.
The allegation, don't read full.
Allegations, sir. My lord,
what are the allegations?
They were in a long relationship.
Ah.
Subsequently, she got married to
Somewhere else?
somewhere
He
else.
doesn't want
And
to.
after the marriage, about 3 to 4 days, she eloped with that lover. Then again, she came back here that
separate.
we will again get married, leave your husband, and she left her matrimonial, again came back, and he left her stranded at Acharya Vihar, Bhubaneswar. Then she filed this case.
Now this lady is has decided to settle with one man. Okay.
My lord, even the lady had approached the lower court to We will do the case, my lord.
Okay, bring Monday. Tuesday.
Hmm.
49.
Please, your lordship. My lord, here, the petitioner seeks for quashing of criminal proceeding, my lord. On the ground that the present criminal proceeding, my lord, it has been manifestly attended with malafide, with a view, my lord, my lord, alternative and for wreaking vengeance, my lord, this case has been initiated. Initially, my lord, one affair was lodged by the present petitioner. The entire incident, my lord, emanated from a small dispute, my lord, that the children of the petitioner, they were playing cricket, and the ball, my lord, hit the car of the husband of the informant, my lord, of fact number 1.
Yes.
So there was a quarrel. And accordingly, my lord, one FIR was registered by the present petitioner against the opposite party number 1. Thereafter, my lord, to counter the FIR, the opposite party number 1 lodged an FIR against the present petitioner. During course of investigation, the brother of the informant was examined, and all other, my lord, because the petitioner and opposite party, they are the employee of Hall, my lord. And all the, my lord, inmates of that
And file,
my lord, final report as false, my lord. That after that, my lord, that protest petition was filed and cognizance was taken. My lord, the statement of the brother of the, my lord, that informant, my lord,
Yes.
it is at page 40. Lordship, kindly have a glance.
Page 40.
Yes.
Yes.
She completely negative, my lord, regarding the incident. Not only her brother, also all other, my lord, the inmates.
Yes.
They negative that nothing such happened, my lord. And another, my lord, document I have annexed at page 69. Lordship, kindly have a glance. Is a statement at 40. The brother of the, my lord, opposite part number 1. A small dispute, and allegation is for, my lord, 294/506. And with regard to page 69, lordship, I would like to draw lordship attention. My lord.
Bring them. Dispute appears to be very.
My lord. And the page 69, police says that this opposite one a troublemaker, my lord, and to shift her from that place, from the quarter. That is there.
Yes. Issue notice, huh? Opposite party.
Number
1. So and so indicates appeals for this data. Mr. Manti or Mr. Jain,
My lord, further proceeding, my lord.
You move application, we put file code.
And there is an IA, my lord, that will also.
We move application for adjournment, we will see. Settle the issue. Yes.
50.
My lord, item number 50 and 51 of password.
52.
Yes. My application under section 311 CRPs for recall of the two witnesses, my lord, having been rejected, my lord, I have come before lordships. But case under the POCSO Act, my lord, the witnesses who are PW1 and 2 are the father and mother of the victim. They were earlier examined and discharged, my lords. Thereafter, my lords, an application was filed at page 20 Annex A by 2. I formulated the questionnaires and I said that these are the relevant questions to be put to both of them, my lords. And that
PW1 and 2.
Yes, ma'am.
PW1 is
mother and PW2 is the father, my lord.
One is
The case under the POCSO Act, my lord. And they were not that, my lords, long after, immediately after they were.
No. PW1 is
Gitanjali. She is the mother.
And PW2 is Chudamani.
He is the father.
Father, name Chudamani.
If the lordships come to page 20, paragraph 3, the simultaneously PW2 Chudamani Naik, who is the father of the victim.
No, the father of the. Yes. What do you say? Is what do you say?
What password?
What password? She is facing POCSO and all so serious offences. Had it been the victim, then 35, 33, 5 or 35, 3, I think.
Yes, 35.
There is a statutory bar. But mother and father, they should come. One opportunity. One opportunity. Single opportunity.
Yes, please.
You will not seek adjournment.
No.
Yes.
Your lordship, fixed date.
Petitioner agreed by the order dated 6/7/2024, passed by learned special judge POCSO Balangir in special GR case number 25 of 2023, whereby his application under section 311 CRPC for recalling PW1 and 2 has been turned down. PW1 is the father, mother of the victim, whereas PW2 is the father of the victim. Both the witnesses were examined on 1/11/2000
And 8/11, no, something different.
8/11, 1/11/2023 and 8/11/2023 respectively, and were discharged. The petitioner in his application under section 311 CRPC has enumerated the proposed questions to be put to the said witnesses, which according to him is very relevant for the purpose of just determination of the case. Mr. Samantra, counsel for the petitioner accused submits that the petitioners are facing serious charges for alleged commission of offences punishable under section 311, 506, 376, 1L,
yes,
1L, and IPC read with section 10 of the POCSO. The accused persons, the petitioners being the accused, facing serious charges, have indefensible right to defend themselves. Therefore, they are entitled to cross-examine the witnesses produced by the prosecution. Since I'm inclined to allow this petitions and afford a singular opportunity to the petitioner accused for cross-examining the witnesses thought to be recalled by him through his application, under section 311 CRPC. Accordingly, the special judge, what is that? Special judge, no? Special judge POCSO Balangir is directed to fix a particular date, and recall the recall PW1 and 2, recall PW1 and 2, and afford a singular opportunity to the petitioner to cross-examine the said witnesses. Before affording opportunity to the petitioner to cross-examine the witnesses, the trial court may also examine the relevancy of question proposed to be put to these witnesses.
He has already examined and said that not relevant. So,
and you may put further questions also proposed to be.
Yes.
And it's made clear that the petitioner shall not seek adjournment on any ground before the trial court when the matter is fixed for the purpose of re-examining of the witnesses. With this observation, the petition is disposed of. Yes.
Limited there, my lord. Petitioner is not apprehended yet, my lord. Not arrested yet. And only the prayer is petitioner ready to surrender before the trial court, and only liberty may be given. In between, split up trial has conducted and some witnesses examined, my lord. His bail application may be
charge sheet has been filed.
Charge sheet filed to split up trial run madhya galani. Only deposition may be considered while the petitioner surrender, my lord.
What kind of petition is this? I don't know.
My lord, only prayer is petitioner is ready to.
Except FIR, you have not filed anything in the petition.
Yeah,
and you are making all kind of, you are saying that trial has already begun, deposition has already been, the witnesses have already deposed. Where from I'll get all this thing?
Then my lord, pray for next week. I will obtain all things.
What are you asking, by the way, just see?
My lord, petitioner is ready to surrender, my lord.
What option you have? You are the accused. Ready? What is ready? You have to surrender or otherwise you will be arrested. You are not doing any grace to the
No,
prosecutor.
my lord, that is true, my lord. Only praying, my lord, the deposition may be considered while considering the bail application.
Why are you comprehending this thing that the trial court will not consider deposition?
ନାଇଁ ଫାଷ୍ଟ ସେଠି ଗଲେ ଖାଲି ଓନ୍ଲି ସରେଣ୍ଡର ରଖୁଛନ୍ତି ତାପରେ କରୁନାହାନ୍ତି ତ ସରେଣ୍ଡର ଖାଲି ରଖିଦେବେ କିନ୍ତୁ କରୁନାହାନ୍ତି. That's why
you would move a bail application and that should be considered on its own merit. On the basis of the material available on record. That's what you want. As they record it and dispose it.
Yes, my lord. Material available record means that is.
You have been absconding.
Yes, my lord. Now I'm absconding. My lord.
When are you going to appear? You tell me.
Lord, within 2 weeks, my lord.
Charge sheet, when the charge sheet was filed?
Charge sheet, my lord.
Petitioner is accused in one of the accused in Maskun PS case number 57 of 2022 for alleged commission of offences under section 20 B1C and 29 of NDPS Act. After investigation, charge sheet has been filed on 3/11/22, showing the petitioner as an absconder. Absconder. Mr. Padil, the counsel for the petitioner submits that the trial qua the other accused persons have already has been commenced, and this trial insofar as after splitting the trial, and although he is challenging the entire criminal prosecution initiated against him, but he confines his rate to limited relief that he may be allowed to surrender before the court and resort to the remedy available to him under law. On instruction, he submits that the petitioner shall surrender before the court on or before 15th of December 2024 and resort to the remedy available to him under law. He submits that since the prosecution has already adduced evidence insofar as the other co-accused persons are concerned, when his bail application is to be taken into consideration, the same shall be considered on the basis of material available on the record. It is accordingly expected that the trial court shall deal with the bail application moved by the petitioner on its merit on the basis of the material available on record. With this observation, the petition is disposed of. Yes.
Obliged.
Yes.
Item 54, Your Lordship, on behalf of Mr. S.S. Rai, praying for next week, Your Lordship.
Press matter.
Yes, Your Lordship.
On request in February.
Obliged, Your Lordship.
Make this one. This is a case where, my lord, the Project and Equipment Corporation Limited.
Yes.
They have registered this FIR. My lord, the facts of this case is that this company, my lord, specialization is a government company. It specializes in giving finance for export and import and other finances, my lord, for the trading part, my lord. In 2012, 5/10/2012, the Union of India Metro passport approval.
No, notice has not been issued. Let us see. No, this matter requires notice or not.
CBI.
What do you want?
My lord, quashing, my lord, because if my lord will see the FIR, my lord, I am against the CMD, my lord. He is now retired way back in 2014. Transaction period is from 5/10.
Come to the charge sheet.
Yes, my lord. I'm just coming. Because, my lord, the entire transaction period has happened between 5/10/2012 till 14/5/2013, when this 19 crores was financed from the corporation to Matarani company, my lord.
Yes.
19 crores. Now, my lord, there was, when it was financing, there was an agreement, arbitration clause is there, everything is there. They took steps for recovery, NCLT proceeding is pending. But in 2021, my lord, they registered an FIR. FIR was registered, interestingly, under section 420, 120B, 7B, 9 and 10 of PC Act. Now, my lord, straight away, if I take to the charge sheet, my lord.
Yes.
Kindly see, my lord, page 77.
Yes.
This is 16.37. The associate acts on the part of the following accused persons constitute offense under 120B, read with 409, 420, 468, 471 IPC, section 13(2), read with 13(1)D. 13(1)D is omitted, my lord, by Amendment Act 2018, my lord. And if section 30 comes into play, it is also not saved, because you have not taken any action against me till 2021, and I have retired since 2014, and I am the chief, my lord, I was the CMD, my lord. Entire financing was done, and there is a recovery proceeding is there, and this recovery proceeding you have initiated, NCLT proceeding, arbitration clause is also there, my lord.
Yes, come to the allegation part.
Allegation part is nothing against me, my lord. They said that you have only sanctioned. My lord, CMD, under me there are various departments who scrutinizes and everything. My lord, the financing part has been done. My lord, kindly see page 98. Page 98. This is the financing to Mahatarani Industry Limited. Mahatarani Guide letter dated 20th August 2012 have approached PEC with a request to extend financing for domestic trade of iron ore and coal. MTNL thereafter referred to associate is engaged in manufacturing of sponge. Thereafter, my lord, as per the discussion held along with the associate finance with the parts, following terms have been agreed. Associate will give the post-dated checks for amount of finance by PEC along with an undertaking which will remain with PEC collateral security and which will be returned to associate on successful completion of the contract. PEC service charges will be 1.5%. The associate shall finalize the purchase orders with the supply and dump the same inside the factory under the supervision of the security. The associate shall be responsible on manufacturing, operation, and insurance of smooth functioning of the cargo. They will keep the PEC informed of the statute of cargo on daily basis. Associate shall arrange for a copy of purchase invoices of stocks. And my lord, straight away I'll come to the arbitration part. Page 117. Any dispute or difference in respect of any matter relating to arising out of this agreement between PEC and associate, if not resolved, amicably shall be settled at Delhi by arbitration by Indian Council of Arbitration, New Delhi, and award made in pursuance shall be final and binding on the parties. My lord may have seen that there will be post-dated checks. Post-dated checks were received by the corporation, my lord. And my lord, this also here, my lord, I am not a, my lord, here the Arun, the petitioner is not a party of it. It is it has been financed.
Come to page 68.
Yes, my lord.
Read it. First paragraph. How will you get over this? There is a charge of 120p.
Investigation revealed that in spite of above shortcomings and lack of clarity towards financing debt ownership of the said company, MTIL, the accused person, namely Sri A.K. Merchandi, the
That is you.
Yes, madam,
Yes.
that is me.
Yes.
And Sri Rajiv Chakravarti, the then CGM director, Sri D.K. Gupta, ex-CGM, consultant Sri P.K. Bhatia, CGM, Sri S.C. Rishi, CCM, and consultant Sri Rohit Sharma and Sri Y.C. Dupe and CM, and Sri Saurabh Rai, DFM, all PCC Limited, not only dealt, processed, sanctioned the application of MTL for financing.
Process, sanction,
and sanctioned.
Yes.
Process, sanctioned the application. And they are not denying, they have processed it.
Definitely, my lord, they have
There is a
proceeded.
charge of 120B. How
My
may
lord, that-
decipher the
My lord, 120B
at the stage of charge?
My lord, 120B, my lord, kindly see 13(1)(d) is omitted from the statute.
That's a different story. 120, there are other offences.
My lord, 120, my lord, because my lord, I am only of the petitioner, my lord, petitioner is no way connected. My lord, he is.
I have read it out.
My lord.
Read it out this part.
My lord, I am reading this, my lord.
120B is invoked only because of that. You are the CMD.
I am the CMD.
Right.
My lord, kindly see that no sanction has also been taken against him, my lord. Sanction is pending against him. And also, my lord, 19A is also pending. They have not taken sanction till date. And my lord, see the summon part. Summon, my lord, they are saying it is on under.
Come to the next paragraph. Middle of that paragraph.
My lord, and one thing.
Middle of that, read it. Middle.
My lord.
Investigation assigned to you.
Yes, my lord. Investigation has revealed that in connivance with the accused directors of MTNL, namely Sri Piyush Segnar.
So.
Yes, my lord. Got sanctioned rupees 8 crores loan on 4/10/2012 to MS MTNL by Sri A.K. Marchandi.
You.
Yes, my lord.
Specifically.
The
Yes.
investigation also revealed that another 8 crores loan was sanctioned.
Again sanctioned.
Again sanctioned by A.K. Marchandi.
Thereafter 3 crores.
My lord, all this was sanctioned.
You not sanctioned yourself.
My lord, sanctioned, but sanctioned in the highest authority. Everybody is there, my lord. One thing more, my lord, I have not received any money. I have not done. There is nothing that has been coming.
Argue at the stage of trial.
My lord, one thing more can I say, my lord? Kindly see the summon, my lord. Summon, my lord.
To me.
My summon is at page. Sorry.
Yes.
Whereas your attendance is necessary to answer a charge under section 120.
Where are you reading?
My lord, page 839.
39? Okay.
Summon task.
39.
Yes, my lord.
Yes.
Your attendance is necessary to answer a charge of state offence charged under section 120B, read with 420B, and section 7B, 9, 10 of PC Act. These are not there in the charge sheet, my lord. My lord, and 113(1)(d) is omitted.
Can that be a ground for quashing?
My lord, kindly appreciate one thing in the charge sheet, my lord.
You argue all this point to the stage of framing of charges.
My lord,
no application before trial court. I'll give that liberty. No application for discharge and argue. That's the best way. That's the best thing I can give you. Nothing.
My lord, because one thing, kindly appreciate one thing, my lord. One more thing, my lord. One more thing, my lord. My lord, I want to just cite one. This is an action on their part to harass me, my lord. Kindly appreciate.
Don't invite any finding from me because see,
I'm only trying to impose
go by the merits, then I have to record some finding.
My lord, what I am submitting is
better you move application for discharge, argue all this point. If it is dismissed, you have an option to come to this court. Why don't you close? Why are you closing the option? If you insist me, I have to write something.
No, I am not insisting on that.
No, insist in the sense, insist in this petition. While disputing up, I have to write something. It will prejudice you in your application. For discharge.
To that.
Move application.
My lord, what I am saying, because a person, my lord, who has retired from service, who has, and they in the agreement that
while he was in service, he has done sufficient.
My lord, he has done, but you are waiting till 2021 to raise an affair.
That may be a ground for you to get an acquittal. Or maybe discharge.
My lord, 482, my lord, also, my lord, we can come when there is an harassment, clear-cut harassment over here. And my lord, kindly see the
public money, just see the
public money
magnitude of fraud.
Fraud we have not committed, my lord.
I don't know.
We have not committed.
I'm not saying that you have committed.
My lord, NCLT.
You are in bad company, maybe.
My lord, NCLT.
Maybe you are in bad company. And that is the reason you are suffering.
My lord, the fact is that they have given the finance. They are unable to recover. Post-dated checks are with the corporation. And what about the post-dated checks, my lord? They are with the corporation. But now corporation is not taking any action on an NIT. Those cases are not
specific application. You move specific application. I give a direction that the trial court will deal with all the points.
Even my lord, sanction part also.
Every point.
Yes.
Every point you take. So that you will have the benefit of a detailed order from the trial court and tell us that. Yes.
My lord, item 68, my lords. I'm grateful that your lordship restrict the matter today. But unfortunately,
So there is a problem.
That will come before the coordinate bench, man. The lordship may pass an order.
No, I can't pass the order.
Well, unless that is
see that the assignment is it will come to me if it is not a tied up matter.
I understand, man.
I can't touch that file.
Only your lordship observe, they may put up before the tied up bench, otherwise it will not be listed on Monday also, my lord.
I will only tell the DR to get it listed. I will not pass any order. But
Monday, exam starts from Monday, man.
tell the DR to list it before the consent bench. I will not say anything, but I will just a verbal request to the DR to get it listed.
Okay.
Monday.
Minor. Okay.
Okay. You 16th to be listed before the consent bench on Monday. I can write that.
Minor will dictate the order after lunch.
I'll dictate. I'm giving a full liberty to you to move on. Yes.
My lordship, item number 101. Already it has gone for mediation and both are agreed for a mutual divorce, my lordship. And
what do you want?
Fine after 1 month it can be, so that it will be filed mutual divorce after that.
Successful.
Successful.
Lease it after 1 month.
1 month.
Why 1 month? Successful, we will dispose it after.
Second week of December.
Second week of December.
Okay.
Give a copy to.
But the petitioner is there in person.
Then the sale is subject to the disposal of the company petition.
Company petition ta jo achi apna property jo bikri kare company petition
Property is attached.
Now
Now-
it has got no relation to the attached property. The property.
Then why have you written para 3?
Because he had filed the case.
Oh, those things are different. All the cases.
He has other properties which is willing to, which will be selling off and making.
What do you say, sir?
I am not eligible to 30 lakhs more. Your lordship.
The rest of the thing you are agreeing. The rest of the conditions you have no problem.
No, my lord. So that 3 crores I am agreeable. I bow down to your lordship. But regarding payment, let him pay 1 crore first. Then 2 crores, your lordship, for which 4 months I have nothing to say. And only after the payment, your lordship, the amount may be deposited here. I will not take. Only after the payment, I will withdraw the company matter and the criminal cases, not before that.
How many cases you have filed?
Well, I have filed 2.
Given the details, your lordship.
NCLT.
138 to 138 cases in court of the HGM, now JMFC, Bhubaneswar.
2
And
cases.
1 case in NCLT, transferred from this court. Nothing more.
No, there are other petitions pending before this court and.
My lord, here, before your lordship, he has filed an application that my 2 complaint case 138 and his case, which he has filed for taking cognizance against us and the police of Samabit are analogous. That is
But see, what he says is 3 crores, okay, no problem. But to begin with, you have to pay a little more. That's what he says. And he is agreeable to all the other conditions. Once you pay, you make the payment good, then all the cases will be withdrawn.
My lord, he just said that the maximum that he can go for within 15 days to 12
See,
is 1.
it is a settlement. See how many cases you are suffering. Just see,
My lord, both.
three complaint case,
My lord, that is why
one NCLT, and
No, I-
many
no,
other
I-
cases
I'm suffering from 2012.
My lord,
I am paying 14.25% interest to the bank.
So in the interest of both of you, it is better that
My lord, we are wanting to settle it off. That is why, my lord, he is wanting to say that 30 lakhs was comfortable. He will arrange another 10 lakhs. He will arrange another 10 lakhs, 40 lakhs. Your lordship may consider that. They have been in litigation.
I will
for 10
not
years.
consider. Consideration is in his court.
My lord, it will go down to him. He will get 3 crores within 4 months. He will get a little less now because it will be deposited before your
That
lordship.
will be, see, because he wants to sell the property and give you.
Yes.
Your lordship.
You purchase, you have
1 crore.
you can purchase that property.
No, my lord, I am not. From him at least I can. From him, my lord. My lord, this honorable court in company matter has directed injunction and also attachment.
Some other property, not the
No,
property.
no, that factory premises involved in NCLT case.
Which is the property which is free from all encumbrances, which you want to sell it. Huh?
Personal property which also sell.
Landed property or household property? Landed property. What is the valuation of those property? Can you fetch 3 crores by selling?
Yes, my lord. He's saying that he is confident.
Just think over, I can just put it after.
May I pray, my lord?
He says 50 crores, 50 lakhs.
No.
He says 50 lakhs.
I have nothing to say. I will not open my little more than your lordship.
No, that's what he says. 40, then I am saying 50 at least you pay. Deposit it.
Let him, okay.
No, I'm not disposing of the matter.
No, my lord. Let him pay 60 lakhs.
My lord, it will be before
Your
your
lordship
lordship.
saying
He will
50
not
lakhs.
be
Let him pay 60 lakhs.
You come next week, think over it.
He is here, whatever.
Do one thing. Prepare a draft.
Yes.
Draft settlement.
Draft
settlement and circulate it to him, and he will also suggest something and prepare final draft settlement. And I accept the settlement terms. I'll take it on record and keep it pending. After the entire payment is done, all the cases will be.
Okay.
No worries.
That's better idea. Draft it, huh? You draft it and give it to me.
I'll do that. My lord, may I just.
Many cases will be over.
My lord, may I just take this confirmation that it is 50 lakhs? That is the only thing, because again, I'll prepare a draft, it will not come down. That is the problem.
He is very large-hearted man.
Yes,
you know.
I know, my lord. It's
Let him pay 60 lakhs. I will not sell it.
But in any case, listen, if he is giving 50 or 60, in any case, it is not going to be disbursed.
Then let it be 3 months, my lord, not 4 months.
No. Let him deposit 50 lakhs here, and you are not going to. I'm not going to dispose of the matter. And unless he make 3 crores full payment here, nothing will happen.
But within 3 months, not 4 months.
3 months.
Maximum 4 months. Chesta kari sir.
All the terms of yours will not be agreeable.
My lord, what he's saying is, let that be 4 months on record, but if possible, even in 2 months, he will get it done, if it is done.
So then what is wrong in having 3 months? 3 months. 3 months.
Okay.
3 months. So try 3 months. Doesn't happen, then we'll see.
Right.
Okay. Prepare a draft, writing all the conditions, the process in which things will be done, and how many cases are pending. And I'll take that as a part of record. And then I'll adjourn it for after.
And also 50 lakhs draft.
Draft. Okay. Right. By Friday, you do it.
My lord, the draft will be within 15 days. That is the condition, bro.
Wait.
I will prepare the draft by Friday.
First, you prepare the draft by 22nd, you give.
Your lord.
Huh? No, not 22nd, sorry. 29.
29.
By 29th, prepare the draft. Then second.
28th. 27th.
30th is working day. You are not. Okay, then let it be 3rd.
Okay.
3rd, okay? And meanwhile, prepare a draft and send it to it.
I'll do that.
For settlement. Yes.
Grateful.
91.
90.
Item 1.
One minute, I'll just go. all pass over matters, I'll call one after another. Yes, one.
That is matter, my lord. That is the matter I have told my lord 302 case and filed the compromise petition in the village.
Petitioner in this petition has filed.
Second case, my lord. And the first case is the counter to that case.
No, he is seeking quashing of which one?
Both the cases are tagged, my lord, today.
Two. Okay. Petitioner is seeking quashing of the FIR number, first FIR number 505 of 2022. 2022 initiated against him, initiated against them by the opposite party number 2 for alleged offences punishable under section 147, 148, 323, 324, 506, 307, 294 and 149 IPC.
That's it at 307. That's it at 307. That's it at 323, 506, 294, 341.
And after investigation, charge sheet has been filed in the present case on
323.
No date on
my lord on dated 30
at the top it is for alleged commission of offences punishable under
323, 506, 294, 341, 34.
34. 327, 324 is there. 307 is dropped. Counsel for the petitioner submits that the petitioners, none appears for the petitioner on the even second floor. The petitioner in the present petition entry submits that there will be a cross case filed, a cross case which is pending before this court, being Purushothampur PS case number 504 of 2022 for alleged offence punishable under section 341 oblique 294 oblique 323 oblique 324 oblique 326 307 325 34 read with section IPC read with section 31 R and S and 32 V of schedule. In this case also investigation has already been completed. That is filed on
submitted on 31/2022.
For alleged commission of offences
341, 294, 323, 324, 307, 302, 34 IPC, T1 smallest, T2 T SCST P8.
The allegation against the petitioner and the counter allegation by the opposite party. Allegation and counter allegation against the party by the petitioner and the opposite party number 2 are serious in nature, and the offence under section 302 IPC is has been invoked in the present case. Therefore, on the ground of compromise, the ground of settlement, the FIR, both the FIRs cannot be quashed at all. Quashed at this stage. In that view of the matter, both the petitions are dismissed. Yes, sir. Yes.
Sir, may I please? From the Lordship direction, I have telephonic conversations over the lower court advocate. Injury report may Lordship may fix next week. Injury report I produce.
What is this case?
Matter has been settled and both parties appeared here.
And both present.
There is no injury report actually there. 324 is the alleged offence. से पिलांगो गाड़ी देला से पळेला पर से स्त्री लोक आसी रात्र ता बापा माने से बाडले अब पुरे धरी के हाई लेवल
they are not there.
They are present before the summit.
They were present, but the injury report your lordship is called.
Please read off. Yes.
12. Matrimonial. the order granting interim maintenance under 143 capital A of the negotiation instrument act is challenging the lordship was solely on the ground, Lord, that the even if lordship's statutory countenance is into the order to reveal that it has been mechanically passed. Only one line that since the case is instituted after amendment came into being, so it applies. By humble submission, the learned court has not adhered to factors which are related or which are essential for consideration of the provision. That is, that is, yes, there is. Because the only one line, the act came into being before that is. Even if
where is that order?
Input order, Miller. Page 20, Miller, 20, 119, I filed an application for 317 dispensing that was rejected, and then immediately passed that order on the application filed by the complainant. 20, Miller. 20, last paragraph, Miller.
Yes. Here is the petition. Here is the petition. Objection.
Order. Here is the petition, etc. The 3622. The amendment provision 143, etc. from 2918. So only. This is the consideration of the learned court while adjudicating application purportedly filed under 143 capital A of the Negotiation Instrument Act.
What is wrong in you?
My humble submission that the court if it was permitted, that is that the factors means what is the relation between the complainant and accused, what is the prima facie case of the complainant. There are so many factors. That is the Supreme, if you lost possibility. That there are the factors while adjudicating 143 capital A of the Negotiation Instrument Act, the court has to delve into the matter to see what is the because I have not done so pleaded I'm not guilty. But on the date of entrance, I entered appearance, I filed an application because I was suffering from ailment, and the court rejected. 317 petition rejected and passed this order.
I don't think there is any illegality in this order.
Illegality? If you, there is one.
That's the mandate of law, what to do.
That is Rakesh, if you lost the permit, Rakesh Ranjan Srivastav.
Judgment says that it is not mandatory, it is directory.
Yeah, besides, it is not mandatory, discretionary, and that discretionary power has to be ought to have been exercised, keeping in view these factors. That the factor has been delineated by the Honorable Supreme Court as
yours is only 60,000 rupees. 60,000 rupees only. 60,000 rupees only.
Yes. But the merit of the case is the security check. That relation the relation between the complainant and the accused is that the check for security check. That if you lost permit, sorry. These are the factors.
You pay 10% and move an application. That's the standard order.
Yes.
Pay 10% and go and move an application.
Application keeping in view.
Yes. And the remaining 10% will be decided.
That will do. Yes.
Petition is agreed by the order dated 2/2024, whereby the court of JMFC all has directed him to pay 20% of the check amount. 20% of the check amount as per the provisions under section 143 capital A of NIF. NIF. The counsel for the petitioner has received the sale order on the ground that the trial court has not taken into the factors required to have been taken into consideration while deciding the application under section 143 capital A of NIA. He has relied upon the judgment of the Honorable Supreme Court passed in criminal appeal number 741 of 2024. Rajesh Ranjan Srivastava versus the state of Jharkhand and submits that while deciding an application under section 143A of the NI Act, the court is required to take into consideration not only the prima facie case, but also various factors like the nature of transaction, the relationship between the party, financial health of the petitioner, etc., etc. He has laid out the impugn order, the reasoning of the impugn order recorded by the trial court. Revision of the impugn order reveals that indeed these factors are not taken into consideration. Be that as it may, I am not delving upon the merits of the case. However, suffice is to say that the petitioners are, to begin with, the petitioners are deposit 10% of the check amount as check amount and move an application before the trial court where various of the order dated 2/2/2024. If such application is moved, the same shall be considered on the basis of the judgment in Rajesh Ranjan Supra. Public. With this observation, yes.
80.
Yes.
Item 18.
18.
Item 18, Your Lordships, on behalf of Mr. Mishra, I pray for an adjournment, Your Lordships, because he is under some personal difficulty, Your Lordships.
What happened?
Item 18, Your Lordships.
Yes, what happened?
I pray for an adjournment, Your Lordships, because Mr. Mishra is under some personal difficulty. And
Simply urgent it. February, yes. On the yes.
Please also.
Yes.
This matter arranged on complaint case matter. So the fact of the case is concerned with the present P number 2 being the complainant filed a complaint case that is under annexure 1 minor, at least 10 minor, to the effect for the commission of alleged offence under section 500 IPC manner. To the effect that the initially an FIR was lodged by the present petitioner against the present OP number 2 that was subsequently final report was submitted. Against that, the present petition filed a protest petition that was dismissed. And all these things were published in the daily newspaper, in a daily newspaper. You will also have a glance at page 12 now. And also I have got the...
Was this matter taken up yesterday?
No.
The same matter, I think somebody else asked me. Okay. Anyway, yes.
Got me also the certified copy of the final report. That examination in chief of the complainant. You will also have a certified copy.
You filed it? Yes. You have not filed anything?
No, I have filed the complaint. I have
except complaint, nothing.
In view of the, as your lordship knows, in view of the apex position, where the initiation, since I am coming within the purview of exception 4 of section 499, the magistrate is to dismiss it. If prima facie is
how is you are falling under
yes,
the description?
Because that your lordship 490 was saying glance at 499.
Yes.
The defamation is no defamation.
The trial is going on.
No, madam. Only summons has been issued.
No, then what is this statement?
That is statement of examination of chief, where he has stated that since it has been published in somewhere last person, last year ago.
In the same
incident was published in Sombar newspaper on his charge the other surplus. On the basis of which he has filed this complaint. That is since in view of the
this evidence is recorded where? In this petition, in this case, complaint case?
Yes, madam. Prior to issuance of summons.
Is the initial statement, pre-summoning evidence?
Exactly.
Then where is the question of cross-examination before the defense counsel declined? Where is the question of cross-examination?
I am saying that since that
no, it is written there, therefore I am saying.
Yes, ma'am.
If it is a pre-summoning evidence, there is no question of cross-examination.
Only on the basis of, because after complaint case was filed.
No, you are not sure about it. This is recorded on 29th What is the date? 29th. What is the date? When this statement was recorded? When the statement is recorded, nowhere is date is the 29th. There is no date.
Exact date I will discuss. But that I have here in the.
You tell me, but let us understand what is this first of all. This certificate copy which you are supplying, when the statement was recorded, give me the date.
With regard to date, I am not telling straight. For lordship record. Because date exactly that is not there. The lordship is-
Very funny.
Because I am challenging the order that has been, that is the initiation of the complaint case.
You are relying upon this.
I'm not relying. I am showing that with regard to, because that is not there.
Just you tell me whether this is the statement, it is a pre-summoning evidence or the trial is going on.
No, pre-summoning. Trial has not.
If it is pre-summoning evidence, where is the question of cross-examination decline? It is written here.
That is yes. Yes.
Then how can it be pre-summoning evidence? Have you
Yes, ma'am.
gone to trial court any time?
Yes, ma'am.
In a pre-summoning evidence, where is the question of
exactly.
cross-examination? And it is written here, cross-examination of defense counsel decline.
Decline.
Then
I'm not telling.
then the trial must be going on then. This must be this.
Your lordship has that next page. I have stated that.
So therefore, you tell me the date. The
Yes,
situation is also not there in the entire evidence.
I think, and
What kind of
but here they have initiation of the complaint case is under challenge, man. Because in view of the appeal petition.
if you have already participated in the trial is going on, I am not cutting the trial at this stage.
But I am not yet.
And now I started doubting because of this certificate copy.
I will. But I am challenging the initiation.
Simply adjourn for second week of December. Second week of December. Yes.
29, may I please?
Yes.
In that case, Melody, that the present petitioner is challenging Melody that filed the instant CRL petition seeking for a direction to set aside the order dated 13/3/2024 passed by the law and JMFC to Cognizance Melody. And to direct and the place to direct to restoration of the said 1cc case Melody. The fact of the case Melody, the present petition
has been dismissed for defeat.
Melody on the said
That page 26. The lordship annex of 3, page 26. Order dated 20 January 2024. Both the parties.
That also you are not taken.
That was not my mistake, Melody. I am satisfied, Melody. My grounds is Melody.
On 20th January 2024.
As for the, I have written in the para 5 Melody. Court website on that on dated 21/24, the matter was posted to 6/5/2024 for evidence. At that the same time, the matter was posted to 13/3/2024 for evidence. The kindly remove page number 25. That was 25. In the set, the business on date 21/2024. It was the date that hearing 6/5/2024 evidence. Evidence applicable for the evidence applicable, the date was posted to 6/5. Thereafter, for the mistake of the court website, that was that was had by the 13/3/2024.
No. Before that, you just see. January 2024, there are two entries.
Yes.
In the first entry is correct. The second entry is wrong. The first entry is 13/3/2024. According to the matter was listed and dismissed.
Yes.
That was my Lordship. I have written my Lordship.
I am reading your document only.
The petitioner was examined and cross-examined, but that was I have written in the Lordship.
No, show me the proceeding.
Proceeding
when the petitioner was examined and cross-examined. Is it happened on 20th January?
Both parties have absent.
No, but on the set, the both parties were absent. The advocate passed my Lordship 13/3/2024. That was
They are also both parties.
that only
read that. You tell me what happened in between. You are relying over page 25. 25 speaks about something else.
25 my lordship, the counsel for the petitioner on para 5 I have written all things in my lordship.
Shall I believe the court record or shall I believe your evidence?
Court record my lordship.
Proceeding is there in front of me.
Court record is the 6/5/2024, but the dismissal for default has been passed order 13/3/2024.
Right me, just see. Okay, come to page 25.
My lordship, page 25.
Just see.
Huh.
20th January 2024 was the date.
Date.
It was adjourned to 13/3/24.
No. Hearing date is 6/5/2024.
Just see the entry before that. Why are you wasting time?
No, see.
Just see the entry before that.
Well, on the said date, the
two entries. See the first entry. First entry is 13.
The court directed.
The court has rightly taken up the matter. 13.
Court directed to the second entry is 6/5/2024.
Second entry, you forget about it. First entry, as well first entry, the matter was supposed to be listed on 13. And the matter was really rightly listed on 13, and it is dismissed in default. You were not there.
So adjourn this matter, I am satisfied on some movement and judgments is there. So I am satisfied with such judgment.
Judgment, this is how, what kind of practice you people have adopted, I don't know.
I am
If
satisfied.
the is not agreeing, adjourn, I'll get judgment. In these are the factual disputes. Where will we get the judgment? What is the proposition of law, you tell me?
The dismissal of complaint amounts to the actual time of the accused also.
Obviously.
That was that.
I am agreeing with that.
Doctor, I am satisfied on the said that I am
agreeing with your proposition. You need not show me the judgment. I am 100% agree.
There's some relevant judgments. I will collect my I will produce my on the next date. I will produce.
What to do? I just don't understand. You have not seen your file properly. Just see your file properly. I don't know how. What to do?
Adjourn this matter.
What is the complaint? Let us see. What are the offences? If serious offences, then I'll think of. Otherwise, what are the offences?
138 proceeding under NI Act has been assailed in and the present petitioner has lent 5 lakhs to the opposite party number 2, and as the opposite party had requested the same, but the opposite party number 2 had assured the present petitioner to refund the said amount. But
okay, you take out the notice to opposite party number 2.
Obliged.
138 NI.
No, my lordship, that.
Okay, that's what I'm saying. He has to take. It's a matter of 138.
Yes.
Bring him. We'll see. 2 lakh rupees check is dishonored.
No.
Because it's a statutory complaint. It's very difficult. Get him.
What happened? Also, notices.
Issue notice to opposite party number 2. File requisite by tomorrow. Get him.
Yes.
The normal complaint could have been done, but it is 138. So therefore, his notice has to. His remedy goes. That's the problem. Yes. See, these are the things you understand.
I have police militia.
You, while arguing, you should know every aspect of the matter. Anything can come in the court. What she was saying, you could have filed that was running in my mind.
That was
when you say 138, then I thought no.
I was on the said judgment.
You have to be careful about
138 militia. Right.
Okay. Yes.
May I please, Your Lordship? I am the director of the company. I am the director of the company. Well, the present opposite partner number 2 is the managing director of the company, Vivian Millers. Now, the arising out of complaint petition, 156.3 Millers, the FR was registered. Now, the background of the story is when I have sold the property of company, that is the FR was lost. Now, Lordship, for a moment, what are the background of the story? Where I have entered into a general power of attorney with the landowner. Then, subsequently, the said property was sold to the company, to the managing director. Then, the managing director entered into the agreement with the one tribune company, the developer. That means the developer agreement was a Lordship may kindly see that page 56 agreement. The agreement is relevant is page 59 for a moment.
59.
59. Yes. Then my lord, where paragraph 4, that out of 4 numbers of flat apartment allotted by the first party which is under. The 2 flat in name of the one of the director, one of the managing director, and 2 flats is name of the company my lords. Then my lord, the boilers, but your lordship, my memorandum of association pays 80 millions. The company was established in the year 2010 millions. They pay 71. That is, my lord, 18th day of January. What is the case? Well, the stage, my lord, the investigation is on. Now, my lord, the kind of moment. The same cell cause of action, the suit was filed, my lords. By the same, my lords, the man. Go and tell me there. The same suit was filed prior to lodging the FIR. Suit was filed, my lord. Tell all this. I said, am I investigating or no? I am pardon me, lordship. Many things are there. Lordship, only one can counter transaction. I'll show you all the documents before the IO because the NCLT proceeding is there. Once the NCLT proceeding has also filed objection and they raise all the grievance below. Now the laws are filed, lordship. Prior after 110 so lordship, the
petitioner is seeking quashing of the FIR number so laws against him by opposite party number 2. Opposite party number 2. In entry alleging commission of offences punishable under section so and so. FIR means the investigation of the present case is still going on. The petitioner, by filing a series of documents, tried to demonstrate that no case as such is made against him. The investigation for the case is at the nascent stage. Therefore, I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to apprise all these aspects to the investigating officer, who shall deal with the same in accordance with the law while filing the report under section 173 CRPC. Yes.
And lordship, target the one some period will be the investigation will go. Otherwise, running
lot of dealing has taken place. I can't.
Lordship, 2020. Lordship, 2023 FIR has been launched. That FIR has been
no. These are the builders and all. They purchase land from someone, sell to someone, and taking money for someone else.
Yes, Lord. That all the facts has already been taken from some other
transaction.
That is, Lord.
It is not an easy transaction.
So, Lordship,
back-to-back transaction, taking money from someone, selling the land to someone else, and thereafter you say that I am MD. I am not responsible. All the stories.
No, suit is filed. Therefore, I come. Now, only experience that is lordship. Kindly, my lord. So the proper investigation into the matter.
Next, yes, Mr. Tripathi.
My lord.
Yes, got it.
Well,
who will the judgment? Same similar matter, 5-6 matter I passed over now.
My lord.
Today.
Here in this, you are my lord. Your lordship.
Which paragraph?
Actual accept, my lord. Your lordship, paragraph 2, my lord.
Paragraph 2.
Paragraph 2.
Yes.
May I read second paragraph?
Yes.
Actually, that aspect of that case and the
let him see his study.
FIR number such and such dated 8/1/2000 was registered Sadar Gangpur police station district such and such Rajasthan at the instance of 4th respondent. The father of the victim involved of the case and the 3rd respondent here in section 354A,
yes,
342, 509, 506, and 7 and 8 of the POCSO Act. And C and SC. Thereafter, the allegation therein has to be effect that on 6/1/2022, when the victim child, then a student of class XI, higher secondary school, was alone in the classroom, the 3rd respondent, who is a teacher, came there and after gazing through the window to ensure that nobody is there near to the classroom, he reached behind her and started tapping her cheeks and soon put his hand inside his bodies and rubbed the breast. In anguish and anger, she got up and ran away. The accused followed to stop her and hurled abuses with ugly words like dead chama. Thereupon, she sat down near the gate and to the teachers for help, but it was no avail. They pursued up to the tight-lipped about the incident. Though the principal came to the know about it, he only took her signature on a blank paper. Meanwhile, one teacher came to the resident of 4th respondent, took his wife to the school, telling that her daughter was not feeling well. On reaching there, his wife found the daughter in a deadly terrified and and she could say nothing to the mother. But on the reaching home, she divulged the incident to the mother, the wife of the respondent. She in turn informed him on the mobile phone as he was away in a village for employment. On the next day, Both came back home and victim narrated and then he lost the FIR. My lord, in this case, my lord, your lordship was, there are two issues. Your lordship may kind of have glanced to page 8, paragraph 6. Here in this case, my lord, what happened, the accused and the informant compromised the matter. They have approached the Honorable High Court. Honorable High Court quashed proceeding.
Relying upon Gyansing.
Gyansing and at the stage of FIR. No charge sheet, no nothing, investigation at a nascent stage, my lord, and quashed the FIR. After that, my lord, one of the villagers approached the Supreme Court. He is not the party. So there are two issues before the Supreme Court, my lord, paragraph 6. Whether a third party to a criminal proceeding got locus standi to challenge the order of passing FIR concern and all further proceeding.
But what is the ratio decided?
Decided, my lord, you must know, and then second.
These are the facts of this
These are the
case.
facts.
Okay.
Thereafter, madam.
And you want that the factually your case is distinguishable.
Distinguished, madam. Let's begin then after page 28, paragraph 24. 24, madam. Paragraph 24, page 28.
Yes.
My lord, the learned amicus curiae submitted that a scanning of the decision of this court in Gyansing itself will reveal that the legal position in regard to this question. The question amicus curiae drew your attention to paragraph 48, 57, 58, 61. My lord, the relevant is, my lord.
Is reproduced.
My lord. Your lordship may kind of glance to page 32.
Yes.
That underlying, my lord.
Yes.
In other words, the High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding or continuation of the criminal proceeding would tantamount to abuse proceeding.
Yes, that's the law. That's the law of Gyansing. Yes.
Thereafter, my lord, your lordship, page 33. 7 from the top, man.
Yes.
Having understood the position of law on the second question, that is the bounden duty of the court concerned to consider whether the compromise is just and fair. Besides being free from undue pressure, we will proceed to consider the matter further.
Yes. As the result of the impunity.
In that case, my lord, FIR was lodged on 18/1/2022. And in the FIR, he has stated that he was forcing me not to lodge FIR. The informant in the FIR. Thereafter, after 22 days, my lord, there was a compromise and approached the High Court, and High Court passed the proceeding. And after proceeding, your lordship, page 26. Sorry, paragraph 26.
Yes.
That is the observation. In this context, your lordship, what is? It is noted that the complaint which led to the registration of the FIR was filed on 8/1/2022, and the compromise was entered into the between third and fourth respondent within a few weeks. Thereafter, on 13/1/2000, a perusal of the impingement revealed that without even referring to the alleged offence, thereby without looking to the nature and gravity of them, solely relying upon the compromise, the High Court observed thus. It is, my lord, thereafter, my lord, from para 27.
Yes.
It is also be noted that the quashing of the FIR and further proceeding, the SHO of the police station concerned was directed to file a closure report within the concerned judicial magistrate within a period of 1 month from the date
This was not permissible.
No, that for that
you give a direction to file a closure report.
And for that matter, your lordship, para 28. Your lordship, a bare provision of the impugned order and the light of the objection binding on the Gyansing, bearing in mind the allegation in the subject, it will be revealed that the High Court has misread and misapplied the law down in Gyansing case to quash the subject affair and all other proceedings based on pursuance thereafter. We are at a loss to understand how the High Court arrived at the conclusion that in case and that the dispute to be resolved existing between the parties and the third to maintain harmony in the affair and all other proceedings, there should be quash even without adverting to the allegation raised against the third respondent in the same. It is also fact that though in terms of the decision and irrevocable duty of the court to consider whether the compromise could be acted upon or not in the interest of the impugned order would reveal that the High Court has held to this proper consideration in that area. Next paragraph. In this particular situation, that is a decision what is to be considered while passing the.
Well, that whether the FIR is possible or not would depend upon the facts and circumstances of each case. And while considering the question, the court has to apply its mind. One, whether the crime is one of the against the society.
Society or against an individual alone.
Nature of the the seriousness and how the crime was committed, see whether the offense is one of the special statute, and that is the stage of the proceeding, and how the accused will make to compromise with the complainant. In this regard, it is revealed that the case in hand victim was the student of class. Para 31.
31 is in view of the very object purpose and the purpose, we find them reason to disagree with the conclusion paragraph 12 extracted above in the given case. It is more so when the extracted portion of the complainant that it was annexed to the FIR and extracted in would reveal that the accused was making pressure on him not to lodge any report. Despite giving such statement in the complaint, within a couple of weeks, the accused managed to compromise the case with the fourth respondent, his wife. Here is the pressure, my lord. He has finally compromised.
Power of 6482. Para 32 it is.
My lord, so that 32 my lord, in on behalf from both held that power under section 482 CRPC could not be used to pass a proceeding based on conduct if it is in respect of a heinous offense which are not private in nature and have a serious impact on the society. When an incident of the appropriate nature and gravity alleged occur in a higher secondary school, that too from a teacher, it cannot be simply described as an offense which is purely private in nature and no serious impact on the society. And thereafter, my lord, in this, so far my case is
actually is see there are two parameters has to be considered. Whenever if the offences of this nature, whether it has a
paragraph 32, the ratio is the court held that power under section 482 could not be used as quash proceeding based on compromise if it is in respect of heinous offense, which are not private in nature and have a serious impact on the society. Two aspects, private nature and public, that is described in paragraph 61 of the Gansing case. Page 31.
Yes. Now it is all now depend upon the nature of
yes,
affidavit.
Yes,
affidavit.
Yes,
you are going to file.
My lord,
I'll read the judgment, then I'll try to
my lord, in my, so far as my case is concerned,
show me your affidavit.
I
See what are the ratio is. What I have to see whether just see para 32.
My lord, how the affidavit
In respect of heinous crime, heinous offenses are there, no problem. Which is not private in nature.
Yes,
you have to bring your case within that. It is no more a private in nature because both the family members have now decided to.
In the case of Gansing, my lord, heinous crime this is described.
Yes,
heinous
crime always described.
57.
Heinous crime always described.
Serious offense of mental
Targeting
of offenses like murder, rape, adultery. So, in a case of minor, the POXO case, your lordship is already in the hand. And in a case of rape, then it is also heinous minor. That cannot be compounded because it impacts the society.
When are you releasing the earlier months? Huh? 3rd December. Release this also 3rd December.
All these. 37
all one after another and decide. Yes.
and 39.
37. Please, Lordship. Lordship, petitioner challenging the order dated 1/10/2020.
Yes.
The petitioner challenging the order dated 1/10/2024 passed by the learned JMFC Potamunde in GR case number 400 of 2016, whereby the recall application of PW12 is rejected. Recall application 311 application of PW12 is rejected, madam.
PW12
Yes.
is rejected.
Madam.
Yes.
My lord, I have annexed the deposition of PW12 at annexure 4 and also the questionnaires which was subject to asked to the PW12 in the recall application, that is, my lord, at annexure 2. Annexure 3 in Annexure 3 series.
This, I think deposition of PW 12 we have filed.
My lord, at Annexure
Where?
4.
Yes, this is not complete. You have cross-examined.
My lord, that cross-examination has to be done with that questionnaires which was rejected, my lord. My lord, PW 12 is the mediator who was present at the time of family settlement.
You are the accused.
My lord, I am the
Just see the examination in chief.
My lord, I have seen that, but
One line examination in chief.
my lord,
And you cross-examined for 3 pages. In the cross examination in chief, what PW 12 has said? I have no knowledge about the incident. This is the examination. And if you want to, you have cross-examined him 3 pages for that. And you want recall of that witness.
my lord, for that
A witness who says, I know nothing, you being accused, what do you want? You want a conviction?
my lord, I want examination because what he have stated.
Because you are insisting that you know.
What he have stated before the IO, which
No.
My lord, what he have stated before the IO in PW as IO is a PW.
See cross-examination, madam. 4 pages cross-examination.
That
Examination is 1 line. I know nothing in this case.
Lord, I have seen that cross-examination.
That I reflected in the impute order.
I have not read. Where is the impute?
That is page.
That must be the reason, obviously. To be.
Page 35.
35.
There is the case record, documents available in on perusal of the evidence. Adduced by PW 11, it is found that he had denied to know anything about the case. In his
That's what I'm saying.
He denied that he put his signature in a blank paper. That's why he denied everything. But in this cross, and that's why he wants to recall that witness for the case, my lord. One chance may be given, and I have annexed the question.
I would have given, but it should be genuine cause.
Lord.
A witness who says I know nothing, you have already cross-examined.
Just because he don't know anything, because he put his signature in a blank paper, and that document exhibited in divorce proceeding. It's connected. Petitioner will be prejudiced, my lord.
See the scheduled questions.
My lord.
Page 28.
Yes, ma'am.
Read it.
The question relating to the content of Xerox documents seized by the IO in Exhibit 1 by
Xerox document.
My lord.
Okay, next.
The question relating to the original document Exhibit D1 to be shown to the witness or proved his signature content thereon. Have you interacted with the informant, that is PW4, her father, PW1, including the accused person and other witnesses?
Yes. Come to the cross-examination. Come to the cross-examination.
One chance, my lord. That or else the divorce proceeding will also be hampered. Just because of this PW12, everything is connected with the PW12 because he was the middleman at the time of family settlement. That family settlement Xerox copy, my lord, at annex to page number 30.
Which one? It is 498.
Yes.
This is the family dispute. I'll just simply issue, I'll not allow the petition, but I'll issue notice, let them come. Okay, I'll just issue notice. You don't have a case, but since it is a matrimonial dispute, I'll just issue notice.
But
something may work out.
The GR proceeding is going on, and he may close down.
Do application for it.
That's why I'm filing the IA is for there for.
I'll just explore a possibility of settlement, that's all. Can't be called like this, right? See your memo parties.
I have not.
What way one can help you? Tell me. You have not implemented either. It is a 498 case. Informant is not a party.
I am permitted to add her report.
I don't know why people are doing like this. Put it next week, we'll see. Do whatever, next week we'll see. Yes.
39 also, that's also 164.
Third. Yes.
41.
That is 1000 pages.
1000 pages.
My lord. I also. Again.
At each cost.
I can't write that.
Your lordship.
Well, that will be against the law. You are the prosecutor, you are the everything, but I can't write in the judicial order that accused will pay money for taking the document which you have filed to prosecute him.
No, my lord, obviously.
If there is very rich client, he will pay. That's a different story, but I can't write that. Right? And petitioner is agreed by the order detail. Where is that order, madam?
My lord, the page 89 to 92, my lord. Two series.
20th August 2024, passed by 20th August, no? Where is that? Passed by Special Judge Vigilance, Renkanal, NTR case number 1 of 2024, whereby where is the operating part? You moved an application?
I moved an application, my lord.
Whereby the application of the petitioner accused under section 207 CRPC has been turned down. Notice was issued to the Mr. Maharana appears for the vigilance on advance notice and submits that the document sought to be supplied to the petitioner is consisting of about 1000 pages. Without entering into the merits of the case, he submits that the petitioner will be supplied with the copy of the entire document relied upon by the prosecution in the FIR, in the charge sheet. Accordingly, the petition is allowed. The petitioner, the trial court is directed to pass appropriate order under this order, directing the IO of the present case to supply the entire set of document as has been enumerated in the which is form part of the charge sheet. Yes.
Highly blessed.
Yes.
42.
Order of cognizance and issuance of processes against the petitioners are not challenged. Here the offence is under section 120B, 379, 411, 413, 467, 468, 471, 472, and 34 IPC. And read the section 21 of the Mines and Mineral Acts Act, against which cognizance was not been taken. So for the IPC offences are called, cognizance is taken. Present petitioner number 1 is the owner of the truck, and petitioner number 2 is the driver of the truck. The main allegation was against the transporter of the present petitioner who hired the present petitioner's vehicle. The petitioner's vehicle, the transit pass, on the strength of which it was allegation that there was a false transit pass, that was subjected to verification by the investigating officer. And it was duly report was duly received. Your lordship can have a glance for that purpose. I am taking your lordship to my lord page.
Yes.
35. Annex 3. Annex 3, this is the letter forwarding the transit pass for examination. Your lordship will find that is in respect of our vehicle, clause 5, page 36. Check gate copy and destination copy of transit pass yellow color from such and such OD 35B 1594. The petitioner's vehicle.
Yes.
Now thereafter, on the basis of this direction, the MCL issued the letter, next page 37, that the code transit pass such and such number issued against the vehicle number as asked for has been generated as aforesaid from the date Bhubaneswar OCP. Thereafter, the mining officer also reported, your lordship, Annex 5. Page 38.
Yes.
Serial number 5. The destination and check gate copy exhibit A889 e-pass number such and such relating to vehicle number OD 35B 1594 has been generated from Bhubaneswar OCP which has been reported by project officer of Bhubaneswari OCP Mines seems to be genuine also. Therefore, on the basis of this was the only basis, and the petitioners have been implicated as accused. Now, this is a case the STF has lost as many as 29 persons. There are so many transporters are implicated in this case. So because of this case, I am not being able to hire by any other transporting company because we have a criminal case pending against us. But whereas the investigating officer was on the charge sheet also reflected this fact, still then
where is the charge sheet?
The charge sheet, that is a bulky one, legible ta nathila boli annexure kari parni. But that I do have with me. I can give the legible copy of that.
So you have to give file because you are challenging the cognizance.
Cognizance. But this is the basic one.
But that's right. But I have to see the charge sheet after investigation. What has come against you?
That sheet copy, I have the copy. I can give it by getting it typed legible copy because it is not certified copy. I have got the certified copy. The certified copy.
Place it in the copy somehow. I need to know what are
yes,
the.
I can do it.
After 1 week.
Another thing, Your Lordship, the transporter has filed an application. That Your Lordship has put urgent the matter, that matter to 5th of December. Subject to Your Lordship's convenience, can it be tagged with that?
Yes, yes.
That is 869 of 2023.
Yes. List it along with that. Yes.
One more point, Your Lordship. The petitioner, who is the petitioner? It has not been stated specifically in this CRMs, Your Lordship.
Driver and owners.
It has nowhere. It has been the government has nowhere. It has been taken. Rather, Your Lordship may have a glance at page number 6, Your Lordship, para 7.
Yes. Para
7. Page number 6.
Yes. Yes.
It's needless to mention here that the petitioners are being hired by the registered transport owners of the transport company, namely so and so, having its registration number so and so. Look, this is the only piece that has been provided about the status of the present petitioners.
In the charge sheet, it will be there.
Yes,
yes.
Let us see the charge sheet first of all. 5th December.
In that case, Your Lordship called for the case diary also.
If you give the charge sheet, then I'll see.
Yes, yes. I also give the legible copy of the trust.
Get it ready. If you can't file, give it to so that I can read it. Yes.
45.
May I move to the
If nothing will happen, it is only cognizance. Why do you worry? So many accused are there.
So many accused.
By the time they will appear, it will be 3 years. Don't worry.
That is the reason for filing of my
I know. Many petition will follow.
Yes.
You will be enriched by the time notice will be issued. Many transporter will come to you. Yes. Yes.
My please will also not. The checkered history of the case is not the second round. First I was challenging the cognizance that it was remitted back on the ground. See, in the meantime, pendency of the matter, the informant of the complainant dies. So the matter is remitted as to whether the dismissal of complaint, either on account of death or non-appearance, accused is acquitted on that ground, but that has been ramified from the court found, the land court found no. It has not been arising of the complaint. Since complaint is more the state case, GR case, so this provision is not applicable. Therefore, hence the present application to Lordship again reiterates the point of the order of cognizance. The main point, to Lordship was that the present case is that what the I showed, the present petitioner sold his undivided to the extent of his share. Well, he sold to the extent of his share, and the present complainant informant gave 2 checks to the extent of the denomination of the sale proceeds. These are not. I filed, the present petitioner filed 2 1cc case that is pending.
Yes.
But then the present informant filed suit in the month of August. In the month of August, he filed a suit for recovery of the 7 lakhs the sale proceeds, which he
this is arising out of basically
civil suit.
And complaint.
This complaint arising complaint merged with GR case, because one case.
Why have you not included the?
Lord, because it's I will implement state because it's GR case, so, but yes, I will implement.
Implement first, we'll see. Implement.
But informant, then you have, absolutely the informant is Lord. Therefore, the question was raised in the event of the death of the informant, the complaint case, 260 complaint, no, it is GR case only.
Who is prosecuting now?
Prosecuting the state now in the state. Because of the state GR case, the state is the prosecutor.
Now it has become a GR.
Yes. Because the complaint case is merged with the state, the GR case.
Yes. What do you say?
Lordship, there is a specific government that the complainant was then 70 years old. He was the father.
He died.
He has died, but he had given money on behalf of his son. I mean, he has registered this complaint case on behalf of his son. His son used to stay at Dubai at that time. So,
what do you want to tell them?
Since he has died, his son maybe.
What he says is, in the absence of the complainant, how will you prosecute him? What kind of evidence you can get it? The personal knowledge of the informant, he is died, and the entire case is revolving around his statement. He has died. Then how will you procure the evidence? I'm issuing notice. Let us see. You examine it. Secondary evidence also they can bring on you, bring against you. Let us see. Issue notice. Yes. Next.
48.
Particular state, let him have the copy. You also said that. My lord.
Yes.
48.
Stay for the proceeding.
Nothing is going to happen. The complainant himself is gone somewhere else. Why do you worry?
But the state is prosecuting that.
State after 2 weeks, after 1 week, after 1 week or 2 weeks.
First after 1 week.
Prepare the legal issue. Prepare. Don't tell me the facts. On the facts, I am not entertaining. I am entertaining the petition on the legal issue. What kind of secondary evidence you have?
Yes.
Even if you proceed with the prosecution, you need to have some evidence. Otherwise, why should he suffer? Yes.
Second, under the clock of civil litigation.
Yes, that.
Okay.
Yes.
The injury to scalp avulsion of scalp. It's a traction injury due to interruption of long hairs. Later, after 2 days of hospitalization, the injury was discharged. That is the discharge certificate I have already uploaded, but it is on the your lordship's board. I would clarify. Now the injury is here, but it is fit and fine.
Whether it is simple or
that method is resolved. The opinion, you will also see the injury report, the opinion resolved. It is a simple one because it's an interruption of long hairs. Do the interruption of entrapment of long hairs. No bleeding usual, no other grievous. Normally it is simple.
yes, where is the injured?
Injured is
Just ask Mr. Jana. Just ask. Is there any complication, health complication on it? The instance of opposite party number 2, FIR number so and so came to the state against the petitioner. You is the informant Digambar.
Yes, informant is the father of the injured Digambar is here.
Accused? All the 5 of them are there?
Yes, all the 5. One Pradeep Kumar Rao.
But so there is no.
Kapil Rao.
The instance of opposite party number 2.
All 5 are there.
Allegation is the so and so. The petition opposite party number 3 is the injured in the present case. All the petitioner and opposite party number 2 and 3 are present in the court, being represented by their respective counsel, identified by them. They've also filed self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The counsel for the petitioner has taken me to the injury report. From the perusal of the injury report, it reveals that the injuries are minor in nature and minor in nature. However, the final outcome of the final opinion of the doctor is not forthcoming from the medical evidence form part of the charge sheet. After investigation, charge sheet has been filed in the present case on 17/3/2024 for alleged commission of offences punishable under section 341, 294, 324, 307, 506, 34 IPC. The party, when the matter stood thus, the parties have settled their dispute and have filed a, where is this affidavit?
The amendment in the para 6 and 7 at page 5.
You have not filed joint affidavit?
No. Joint affidavit I have not. It is, I have already covered para 6 and 7.
Then their version on record?
Their
informant and complainant's version on record, how will I get? I'm not recording their statement. Their version has to be there on record.
But in view of the settlement, I have already explained.
Settlement means what? The very term settlement means what? Both the parties have agreed?
Yes.
And in the on record, the version of the petitioners are there?
Yes.
Where is the version of the victim and informant? How do you say the settlement? It has to be placed on record. By way of an affidavit, I told you in the morning, get an affidavit also.
Yes, sir.
No. Get the affidavit.
Yes, I will file affidavit.
Right now.
Right now.
Get the affidavit.
Yes, ma'am.
Yes. Right now. Get the affidavit, I'll reproduce.
Yes, sir. Yes, sir.
The version, they will say that we have settled the dispute.
Yes,
on the intervention of elders, whatever.
Yes.
And we have no grievance. All these things you write so that I can reproduce their version.
Yes, just now. We don't have
and pay and subject to paying how many of you are there? Five. Subject to paying cost of rupees 2,000 each to the complainant and the injured. You pay 2,000 each. 2,000 each, you pay 10,000 rupees, 5,000 to informant, 5,000 to the victim.
Yes, yes.
Yes. And get the affidavit.
Yes, yes.
Yes.
That I am reflecting that.
And along with the proof of payment. Come by 4:30 so that yes.
50. Well, the 138th proceeding was initiated against me.
Yes.
Thereafter, NBW was issued because parties went to NCLT and I'm not on that point. NBW was issued. Your Lordship may kindly turn to Annexure 6 at page 67. I had approached your Lordship in CRLMC. Last paragraph, your Lordship may kindly see paragraph 4 at page 68.
Yes.
Further, it is directed. My Lord has got it.
Yes, yes.
Further, it is directed that the petitioner shall appear.
60, yeah?
68, madam.
68, yes.
Last 5-6 lines.
Yes.
Further, it is directed the petitioner shall appear before the learned SDGN counsel within 10 days from today, along with the copy of the today's order, and shall continue to participate in the proceeding without any further default. In the event the petitioner makes any further default in the appearance, it is open to the petitioner in session about the matter to make necessary coercive tests against the petitioner. This was the order. I appeared. I was granted bail and I was contesting through the party. Now, my Lord, I filed a 205 application that my personal appearance be exempted. The learned court below at page 73, your Lordship may kindly see. Last 4 lines. Further,
yes.
Further, it is that he quotes the order. Further, it directed the petitioner shall appear before the learned SDM Keonjhar within 10 days from today, along with a copy of the order, and shall continue to participate in the proceeding without any further default. This is the terms of the order of this honorable court. In the event the petitioner makes a default, it is open for the court to session over the matter and take necessary coercive steps against the petitioner. Now, your lordship, hence it is specified that the court has the accused petitioner shall continue participating in claim without any default. Hence, this court lacks jurisdiction to deal with.
Oh, yeah. He says that I can't deal with 205 application. You can deal with it. Who is?
Well, at 138, 20.
That will be decided on merit. Let it be decided on merit.
He has rejected that I cannot deal with.
This court has not precluded the trial court to decide any application. No. I'll clarify that. In fact, this is a clarification.
Clarification.
Same court which has passed the order.
No, it's a fresh cause of action. 205. Your lordship may remand that can decide 205 afresh because this court directed that you participate in the hearing. That doesn't mean that I cannot file 205.
Yes. This is a complaint case, no?
Yes, madam.
Yes. Petitioner is agreed by the petitioner is accused facing the criminal prosecution initiated by the opposite party for alleged offence under section 138 NIA. The petitioner had approached this court on the earlier occasion by filing CRLMC number 3042/2024. The coordinated bench of this court by order dated 16/8/2024 disposed of said application inter alia stating as under para 4 page 16. Pursuant to the aforementioned order passed by this court, the petitioner has appeared before the trial court, and the trial was proceeding at the expected pace. At that point in time, the petitioner moved an application under section 205 CRPC seeking personal exemption from personal appearance on various grounds. The trial court by the impugn order has rejected the application on the ground that in view of the order passed by the this court, which is reproduced herein above, the trial court has no jurisdiction to decide the application. Accordingly, the following order was passed. Page 74 or at the top paragraph. Hence, in this specification, the petitioner is agreed by the said order. Hence, the present petition is filed. I have perused carefully the order passed by this court in CRLMC 3042/2024. This court has only directed the petitioner to participate in the trial proceedings initiated by the opposite party against him under section 138 NIA. But the procedural remedy available to him under the CRPC has not been precluded by this court to be availed by the petitioner. Therefore, the opinion of the trial court while rejecting the application under 205 CRPC is misconceived. Accordingly, the same is set aside. The application under section 205 CRPC moved by the petitioner is restored to the original file, and the trial court is directed to decide the application on its own merit without being influenced by the observation of the court. Yes.
Well, 51 is same and case numbers will differ.
51 is same, case number. Yes.
Correct, full mark.
Yes.
56.
May I slip? When the hearing of a complaint case, petition like the working as married as PU, the government servant, and two open law is as a contractor. But there are three issues involved. Regarding maintenance of the complaint case at Bhubaneswar and subsequent order of taking cognizance.
Yes.
And the sanction is not taken by the magistrate minute. And third, my lord, the check was bound, the check was given by the petitioner to the complainant, my lord, and that check was bounced. Without filing a complaint, the 138 proceeding has filed a complaint case at Bhubaneswar. Enter 420, my lord. And my lord, the entire incident occurred at Bijapur at Bargarh. And the case was filed at Bhubaneswar.
Let us come to the complaint.
Yes, sir. Can we turn to the annex 1 on the page 12?
What was the check amount?
Check amount was 3,70,000. And after completion of work, the check was issued by this petitioner, by the PO. But the check was not found not sufficient in the account, and it was.
The limitation to file complaint case under 138 NI might have been.
No, it has not been filed, madam.
Therefore, he has resorted to this.
Yes, yes, only because to harass the petitioner.
I need to notice, let us see.
Yes, yes,
but you 3 lakhs, you have get the work done. Why don't you pay? Pay.
Yes,
I'll issue notice, calling.
Yes, madam.
And at the end of the day, you have to pay the amount. You pay it. Finish up.
Yes,
Right. Issue notice to opposite party number 2, returnable.
Sole opposite party.
2 weeks. Opposite party. Opposite party. Sole opposite party. Okay. You take out the notice.
Yes, madam.
And you will let him move application.
After application for stay of the proceedings,
you move application before trial court.
That liberty may be.
57.
The application order. Yes.
No, please, Your Lordship.
Yes, Mr.
This is a case which arises out of a conflict in the administrative domain. The petitioner, my lord, is an assistant professor of neurosurgery. The complainant was the officiating deputy director of the All India Institute of Medical Sciences. Lordship would be pleased to, my lord, take the first complaint at page 24.
24, huh?
24.
Yes. Yes.
And Lordship will see, my lord, at 31. The first complaint has the identical, my lord. I will not trouble your lordship, the identical offences.
Sorry.
And at 31, my lord, it is filed on 18th of August, 2023.
Yes.
My lord, this resulted in a final form which starts at page 37, my lord. I will take your lordship to the relevant paragraph of the final form. And my lord, 37 it starts, the final form.
Yes.
The relevant, my lord, is at page
same complaint.
Same complaint.
Yes.
My lord, page 42 is the finding of the IO in the final form.
Yes.
Kindly take page 42, my lord. Lordship has 42, my lord, last 10 lines to the top where it says it was ascertained. Lordship has that?
Yes, I got.
Lord, it was ascertained that there is allegation, cross-allegation against each other by the complainant and the accused relating to the functioning of AIIMS Bhubaneswar, which is departmental matter and was duly taken up by the AIIMS authority. The allegation of use of abuse...
Come to the protest petition now.
Again, I'm deeply obliged. Now, the protest petition starts at page 44.
Yes.
It's a copy-paste of the first complaint. Entire copy-paste. And why?
He's also a doctor.
He is not a doctor. He was appointed as the senior administrative officer, then became the officiating deputy director. He is not a doctor. The complainant is not a doctor.
You people are there to do good job, not for.
May I notice?
I need to notice.
I am.
He is a doctor. There is a interdepartmental tussle between.
That is a doctor without being without checking the patient, my lordship. He is always involving in the administrative work of the office.
That is because he is the general secretary of the faculty association.
His jurisdiction by entering into the jurisdiction of the complaint. That's the.
And the reason
I'm let him come.
Cognizance order, I'm to appear on 25th, therefore I'm staying
on application, no problem. Remove an application for adjournment, the same shall be considered. Yes.
Let's say SC Act also call bail le janto. SC Act
For that, he has filed a defamation case, my lordship, under section 200.
The defamation read with the SC Act.
Yes.
And I have annexed the evidence on record.
My lordship.
See, in any case, he is a doctor. Okay. These are the ego issue between two persons. Unnecessary wasting court's time and
Yes, my lordship.
And if he will be engaged in fighting the case, how will he treat the doctors? How will he treat the patients?
And he's a neurosurgeon, my lord.
You concentrate on your patient instead of. Okay, stay with.
May I, my lord, take indulgence, my lord? 107, there's a matter, my lord. I thought it will reach, my lord. Is that matter regarding this conflict between the police and the armed forces?
Yes, yes, that is specially assigned to me.
Yes. And yes, and therefore, my lord, I'm only saying notice has to go. There's one case where they have not.
They have to tell me what is the status of investigation.
Yes, status of investigation is going on, my lord. My lord, what has happened? The second FIR by the lady, one FIR, my lord, was of the fiancé and army officer. That was when he was taken into Hajat and put inside.
So what is happening to this inquiry?
It's already on, my lord.
My lordship,
So much proceeding, there are so many things.
my lordship, kindly have a glance to the order of the suo motu proceeding, last order, my lord.
So moto is also there. No, my lord, but these are different things. They are quashing of an application. My lord, notice has to go. Let them take more.
Yes, my lordship.
I'm just issuing notice.
Yes, my
and when this so motu proceeding is pending?
My lordship, it was fixed to 26th on November. Before the Honorable Chief Justice.
I must hasten to add, my lord, the officer of the court, the learned, my lord, the Chief Justice refused to get us to get into those things, my lord. I mentioned the matter, my lord, we would like to become a party in that. The army officer and the fiancé.
That perhaps the reason it is assigned to this court.
He stated, please keep them away. Please use your good officers to keep them out of this. We are taking this in a macro level. Please, we'll take care of the interest. Please don't appear. And if you want to appear, and we would be very happy to get input from you.
Then I'll put it after 26th. Issuing notice to them. Let them come with the status and we'll examine each.
Yes, the FIR thing is important. And there are two aspects, my lord. What has happened, my lord?
They may file a closure report also. Why do you worry?
Yes, sir. No, my lord. Exactly. But my lord, my learned friend may, my lord, the prosecution may find out one aspect. My lord, they made, this is correct, this is something about the telephone which is seized from the armed forces officer, my lord. And that was, they have indicated specifically, let them take instruction that I am telling with responsibility. They have indicated and filed an affidavit in the trial court that we do not need the telephone. And thereafter they have sent it for forensic. My lord, our difficulty is not that. This boy, when he comes, my lord, all the information regarding his posting, where is he going to be deployed, all these things are there, comes in that telephone. These are all, I mean,
you intimate your department not to send message.
No, my lord. Other before the ones that I sent before, my lord, they are also classified.
Where from I'll get that jurisdiction to enter into all these things?
No, my lord.
Investigation with.
They have themselves said that we don't want the telephone.
But now it is sent to CFSL.
Yes, they have to give it back to us, my lord.
After the report comes, they'll give.
Yes. Let them, my lord.
Get instruction that.
Instruction that.
The CFSL
they have seized.
Has examined.
Yes.
It is very sensitive matter.
Yes.
Dealing that level so that we can come to a conclusion.
My lord, if that has been seized, my lord, during the investigation, that is required, my lord.
No. I must be corrected. No. I must be corrected. I'm informing you that the prosecution has filed an affidavit saying we do not require it for investigation. That is the reason I'm saying. You can't take instruction that.
Take it up. Okay. Then shall I put it on 5th of December for status?
Little earlier, my lord, I'll be deeply obliged, my lord. 28th, my lord, I'm before my lord on 27th. If it's 28th, I'll be deeply obliged, my lord.
Get preliminary status reported as 28th. 28th.
My lord, the government has been extremely cooperative. My lord, I have to, prosecution has also been very cooperative.
Sensitive matter, defense and police, and all.
Absolutely.
It's not in case. We will put to rest whatever. And what is happening to that
commission, my lord? They had gone to the police station, my lord, and they made an inquiry. The honorable chief judge.
To give me the terms of reference.
Yes, I'll give that to you. Your lord.
Get the terms of reference.
Yes, my lord.
I have to be careful whether I'm translating in the jurisdiction for the reference.
I'll make sure of
that has to be seen.
I'll address my lord on that.
What is that? Section 5 inquiry?
Yes, 5 inquiry. And now, my lord, 8B has been issued to 42 people and affidavits to be filed. And the matter is posted. We are preponing the matter to 27th because, my lord, the judge, my lord, he is not available. There's some problem on 30th. So we are mentioning the matter of preponing for the purpose of responses to the affidavits. We want, my lord, the honorable judge has indicated that he wants to dispose it of before January 24th, which is the extension time he has been given.
Okay.
He wants.
Let us get the preliminary report.
Yes.
Thereafter we'll
Yes.
dwell upon the real issue.
Yes.
Okay.
And my lord, wait,
28th, get the preliminary report, whatever. What is the status and how things are.
And regard to telephone, my lord.
And telephone also you get the status. Okay. Yes.
Just to recap, 57 lordships pleased to issue notice to stay for the proceeding law. The details are at Annexure 1.
Annexure 1 detail there. No?
The details, the
Yes.
1cc case.
Yes.
Deeply.
Yes. 102. Yeah, 107. Yes. Page number, yes. Yes.
58.
May I please your lordship?
Yes, sir.
My lord, Belgium matter, the petitioner was in bail. My lord, may kindly say annexure 7,
date of
47/11/2013.
Is the NBW?
NBW.
Yes, madam.
6/5/2016. NBW was this.
NBW?
6/5/2016.
Bail.
Bill was 27/11/2013.
Okay. 6/5/2000. Yes. 16.
Yes, my lordship. NBW was issued on
Yes.
6/5/2016.
Okay. Which is this place? This is
Jajpur.
Jajpur. Paid 2,000 rupees. What is the offense?
Offense on the 341, 294, 333, 506.
No, pay 2,000 rupees.
SST.
2,000 rupees, Jajpur Bar Association. Yes.
59. May I please, your lordship? My lord, petitioner was granted interim bail by the learned court below. My lord, on the date of the surrender, petitioner did not surrender but filed a petition for extension of time. And the honorable court was pleased to
Petitioner was admitted to interim bail.
1/8/2024. 1/8/2020.
2024 NBW was issued.
No. Interim bail.
My lord.
Date.
1st of August 2024.
1st of 2012. And subsequently, he did not appear before the court, which led to issuance of
2nd of August 2024.
2024. 500.
Okay.
Yes. 15 December.
Yes, your lordship. My lord, this is a Belgian matter. The petitioner was on bail on 24/3/2023 and NBW issued against the petitioner of 22/7/2024, your lordship.
Yes, 500.
Applies to lordship.
One is the Belgium matter. The date of NBW 6/12/23, date of release on bail by trial court 3/3/12. 500.
62. Warrant issued on 16/4/2022. And pursuant to order of this honorable court, the accused person released on bail. At page 24, your lord.
16/7/2019, he was released on bail. And NBW was issued on 16/4/2022.
22. 500. Yes.
63. May I please, your lordship? Offense under section 138 of NI Act, my lord. The court below was pleased to allow 205 CRPC petition on 21/3/2020, my lord. And thereafter, the case was posted on 29/24, my lord. Case was posted for accused statement. The complainant was present and no step was taken. NBW was issued, my lord.
29/2024.
On 29/24, my lord.
29. And 205 was allowed.
Yes.
205 was allowed. Thereafter, on 29/2024, my lord, NBW was issued.
That's why the fact that his application under 205 CRPC was allowed. The court had issued NBW against him on NBW issued on
NBW on 29/24, my lord.
Could you know this is a 500? Yes.
64.
Warrant issued on 28/3/2012.
12.
Fine.
He was on bail on 6/9/2005.
Where you were there for 12 years? Where had you gone? 12 years. 2012 the NBW issued. Now you're coming 24. Which district Cuttack? District bar Cuttack using 3,000. Yes. 3,000. District court, huh? District bar.
65.
Under NBW issue, my lord, 30/10/2023, my lord. Petitioner as religion bell, 17/4/2013, my lord.
500. Yes.
66.
May I please? My lord, kindly glance at page number 33. That is the charge sheet.
How many bills are still pending?
The first time I see what a city gas.
Bill of petitions are not. Yes. 840. 840 bill applications are pending.
Any.
Yes, imagine.
I'm tired of.
No, not tied up. From there, couple of matters, every day matters are coming. 40 to 50 bail petitions are every day filed.
Because it is the matter after the session judge. Even 506 cases also, it is come to the High Court.
If disposal is not more than at least 50 every day, it's getting piled up. That's the problem.
Bail without CD cannot hear also, but the hearing at the time
That's the whole
of
difficulty.
is required.
That's the whole difficulty. Yes.
Madam, this is the second journal of the petition, madam, and allegation against the present petition is that only 366, 506, and 34 of the Indian Penal Code, madam. And allegation against the present petition, they help the principal accused and they
yes.
Custody since my lord, 12th January 2024, madam.
12 January
2024, charge sheet submitted, manner. In between the trial, charge has not been framed till late, your lordship.
Yes. There are two petitioners.
Two petitions.
What is their role?
The role, Senator Guru Gulu, Joe Dakigani, Prosign Chardele.
That is a victim statement. Victim statement is relevant portion of 161. So CDS
164.
161 CDS CD is not there. ମୋ ମା ନଥିବା ସମୟରେ ମତେ ଜବରଦସ୍ତି ନରେନ ଘରୁ ବାହାରକୁ ଟାଣି ନେଲା ମୁଁ ପାର୍ଟି କରିବାରୁ କେହି ଶୁଣି ପାରିଲେ ନାହିଁ spoiled the area that Western States cough syrup case. Also fixed rate and let it tag with that case. That is
after
56
10 Yes, next.
69.
69, my lord. Your lordship says direct. The lordship says directed me to obtain instruction about that he has not supported the seizure witness has not supported the prosecution case. And he has stated exhibit to your lordship directed me what is that exhibit is you take instruction from the confirmed IO. टिके खाली मंगलवार को आसो ठीक नहीं पर
Okay, next.
I'm not asking most time मंगलवार आसो
Next week.
Mangal, then your lordship may keep it to Tuesday, as has been. Nole nahi puni asibani agu na.
No, all the matter I want to finish it up.
Na, sita.
I'm sorry, the way say it. I'm my lord, your lordship say keep it. I will not take time on it.
That along with 77.
Proactive statement, my lord, that is based on proactive statement. तमें दी जाना को करूँ.
Okay. Tuesday. No, thanks. Yes.
70.
70.
70, may I please, my lord? Well, it is the second round of litigation. Earlier, my lord, it was disposed of because before charge sheet, then subsequently after charge sheet, then Malaya came before this law.
Yes.
So what happened, my lord? Lordship condition in the meantime, the deposition of victim has already been recorded. Lordship kindly see annexure, annexure 9. People lordship kindly peruse the victim's deposition.
Yes.
Annexure 9.
9.
It's a 100% consistent, my lord.
Where
What
is-
happened?
Wait a minute.
Yes.
Where is that? Then next 9.
Annex for nine, page 62.
Yes, deposition.
କପିଟା ଆଜ୍ଞା ଆମର ରେକର୍ଡ ନୁହଁ
ନାହିଁ
ନା ଡିପୋଜିସନ ଟା
ଦେଇନାହାନ୍ତି ପଢିନା
ନାଇଁ ଆମ ପାଖରେ ନାହିଁ ପଢି ପଢି
ଯେ ଆମେ କାଢିଦବୁ
ଆଜ୍ଞା କାଢି
ପଢିକି ଆସିବ ନା
ଅଭ୍ୟାସ ପଢିଲେ ନୂଆ ନୂଆ ଆସିବ ନା
376 ରେ କେବଳ ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ପଢିବ 164 ନୁହଁ
ଆପଣ ଡିପୋଜିସନ କଥା
ଆପଣ ତ ପଢନ୍ତୁ, ଆପଣ ପଢନ୍ତୁ।
ଡିପାର୍ଚର କହୁଛି ଆନେକ୍ସ 9 ଏଇଟା ପରା ଏଇଟା Yes.
ନାଇଁ
ତ ପଢିନା ତାର ମୁଁ ପଢିଦଉ ସେଟା I am the informant in this case. Let's got that.
Annexure 9, na?
Annexure 9, sir.
Statement of victim, yes.
Sir, I am the informant in this case. I know the accused Rinam the Malik in this case. Paragraph 2. In the year 2020, sir, ether actually date of occurrence hochi 2022. In the year 20, I came across the accused while I was putting off in the house of my maternal grandfather at Sino under CORAM PS. Subsequently, the accused provided a keypad mobile phone. So, the mobile phone accused to talk to him. I thereafter started talking to the accused with the keypad provided by him. My grandfather, on becoming aware of my talk with the accused, dissuaded me to keep any contact with the accused and took away the keypad mobile phone. I also started talking to the accused thereafter around 1 year, full stop. In the meantime, I passed my matriculation examination. After 1 year of passing my matriculation examination, I took admission of such and such, such and such, such and such. When the accused, on getting to know my continuing studies in the college, started meeting me and kept pursuing sexual relationship with me, for which I perhaps got pregnant. And I stopped installing intimated the accused.
Come to relevant part.
Sir?
Come to relevant part.
Yes, sir. My paragraph
cross-examine para 7. Don't read all this.
Sir. Second, law of affairs between me and the accused developed at the first stage, that is 120.
You need not read anything else. This is the crux, yes.
She was pregnant.
There was the law of affairs.
Sir,
it's not a POXO case.
Sir,
POXO is there, man. 6 POXO is there.
It is there.
That is there. Sir, ଅଛି ଯେ ସେଟା ତାକୁ ସେତେବେଳେ ବୟସ ହେଇଥିଲା 17 ବର୍ଷ 9 ମାସ କେତେ ସେଟା ସେ ମ୍ୟାଟ୍ରିକ୍
in custody since
custody 9 more than 9 months.
Tell me the date.
Exhibit 5 সেটা
Date.
17 to 2024.
17 to
2024.
Yes. Yes. How many witnesses are there still to be examined?
43. Sir, 43 জন Sir, ସେଥିରେ ମାମୁ ଷ୍ଟେଟମେଣ୍ଟ sir ସବୁଠୁ ଇମ୍ପୋର୍ଟାଣ୍ଟ ଯେ ଯାହା ଘରେ ରହୁଥିଲା.
What is the age of the year?
Sir, 17 ବର୍ଷ 9 ମାସ.
The boy.
ବୟର କେତେ ଯାକ sir? ଦେଖିଲେ 22.
ପାଇଁ ପଳେଇଲେ
ଗୋଟା
ତାକୁ 24 ବର୍ଷ
24 sir.
43 witnesses.
Sir, 43 sir ଏବେ ସରିବନି ସେଗୁଡା sir ମାମୁ sir ଯେ କହିଲାନି ଯେ ମାମୁ ଷ୍ଟେଟମେଣ୍ଟ ଯାହା ଅଛି
ସବୁ ସରିବନି ତେନ
the allegation against the petitioner is found. The petitioner is in custody since 17 to 2024. Charge sheet in the present case has already been filed on.
Filed on, my lord.
Charge sheet कहीं charge sheet 16/4/2024.
After framing of the charges were framed against the petitioner, the trial has already commenced. How many witnesses will be examined? How many witnesses?
7 examined.
7 witnesses have already been examined. 7 material witnesses have already been examined out of 43 cited witnesses. The victim is also examined as a PW2. In her cross-examination, she has stated as under para 7 of cross-examination. It pays cross-examination para 7. Law of affairs between me and the accused developed at our first sight. I became aware of the cast of the accused after 1 year of such law of affairs. Till then, I also wanted to get married to the accused. My love affair with the accused continued for about 8 months. I had already attended the age of discretion. Discretion, what is this called? Discretion when I started attending the college. What is the discretion? I don't know. But I can't change. This is the percentage. Inverted comma. The vital witnesses have already been examined.
Some of the vital witnesses.
Some of the vital witnesses have already been examined. Mr. Das Learned, counsel for the petitioner, has taken me to the testimony of the witnesses and pointed out the contradictions. At this stage, I mean not dwell upon the contradictions between the contradiction in the statement recorded by the statement adduced by the prosecution, adduced by the person. But suffice it to say that he is already in custody. A petitioner is a 24-year-old man who was in love relationship with the victim girl. And as a result of, and they were intending to marry, even they were intending to marry. The trial is likely to take a considerable time because there are 43 witnesses. Since the vital witnesses have already examined, including the victim, I'm inclined to enlarge the petition on bail, subject to condition that the petitioner shall appear before the trial court without fail on each and every date of hearing and shall not create any hindrance in the smooth pace of the trial, in the pace of the trial. With this condition, the petition is released. Yes.
71, please.
Yes.
May I please note?
Sir, I'm for the impairment. Can you take up the any week next week? Any day?
Yes, next week.
I thought date was fixed.
Sir,
72.
Item number 70 to 75. And
My item is 74, connected one.
my item is 78, your lords.
Yes.
All are these part of the same case, my lord. And my lord, I pray, my lord, kindly taken up next week.
Okay, next week. All the
All 72,
72, 75,
74.
78.
78.
Yes.
Arising out of the sentence.
Next week.
73.
Yes. I have already obtained the instructions for antecedent is there, but no antecedent, your lordship.
No antecedent. Petitioner is in custody since 14/4/23. 14/4/23. Charge sheet was filed.
No, there is no antecedent.
Yes, sir. I am not no antecedent.
Yes.
I have already obtained the instruction.
Yes.
Day morning.
Yes.
My lord, he is in custody since 14/4/23.
23.
Yes, charge sheet was submitted on 10/10/23.
10/10.
19 charge sheeted witnesses. Trial is yet to start.
Yes. What are the allegations?
My lord,
Allegations.
allegation is 150 kg, 995 gram. And he is the helper. The driver fled away from the spot.
Tata said the trial is.
My lord, trial, my lord, trial is yet to start. Trial has not been started. I don't get.
Persons to be order dated. I just seek a report from the trial court. You have seen Ravi Prakash judgment.
Yes.
Show me that.
That is Muhammad Muslim and Rabi Prakash. Dita. We have stated in our petition. Right. I have stated. Rabi
Give me
Prakash.
that judgment if you have. I am seeking a report then. Pursuant to
Order
the
dated?
direction of this court, the state council has obtained instruction regarding the antecedent for the petitioners. How many petitioners? Present.
Only one.
He has placed on record the written instruction, which is taken on record. The instruction instruction furnished by IIC Dungri Poli PS reveals that the present petitioner has no criminal antecedent. Mr. Sujata General and Counsel for the petitioner submits that there are 19 witnesses cited in the charge sheet. Charge sheet has already been filed on 10/10/2023. Petitioner is in custody since 14/4/2023. The trial has not yet commenced. In view of the custody of the petitioner beyond 1 year, I am
1.5 years. 1.5 years.
1.5 years. It is expedient that a report is sought from the trial court regarding the status of the case. Which is that court? So court is directed to.
And additional session judge comes special judge Sonpur.
Sonpur is directed to furnish a report within a week regarding the status of the trial. Lease the matter on 20 within a week, na? Then exact 29. 29.
29. Keeping it to 29.
29. And so that I will reproduce that report and Rabi Prakash advantage I can give. Without report I can't.
Yes, that is true.
Yes.
76. Last
Shitty.
4 times, my lordship. Last 4 times, my son.
4 times. Don't delay it now.
Yes,
So these matters are unnecessary pending this long. Yes. Last opportunity. Shitty. Yes.
79.
29.
Here the offences are under section 392 reduced section 25(1)(a) and 25(b) of the Arms Act, Millard, and the petitioner is in custody since 15/1/2024. 15/1/2024. 15/1/2024. On the last occasion, your lordship has directed me to file an affidavit with regard to antecedent of the petitioner, Millard. And the petitioner got 4 antecedents, and out of which already this honorable court has already released the petitioner in 2 cases, and other 2 cases are pending adjudication for bail, along with this case, Millard.
Yes.
Yes.
Say, what are the allegations?
Allegations.
Don't read the sections. I can read. Tell me the allegation.
Allegation, Millard, while the informant was moving on Daringabadi Ghati, Millard, the present petitioner, along with other 2 persons, snatched away his motorcycle, Millard. Snatched away his motorcycle on 28/12/2023. The occurrence took place on 18/12/2023, and the FIR was lodged on 16/1/2024, when the present accused person was arrested in connection with another case, Millard. And in this case, he has been remanded. And
in which case you were in custody?
I am in custody in connection with. I am in custody in connection with. Initially, I was in custody in connection with Baragad PS case number 16/2024, dated 15/1/2024 for commission of offence under section 370. Baragad PS case number 16/2024 for commission of offence under section 379, 411, 34.
Where is in your affidavit you have not stated that?
Yes, madam. In affidavit I am stated.
What is the GR case?
GR case number 39/2024, Millard.
You are in custody in that case?
Yes, my lord. While I am custody in that case, Millard. In this case, I have been taken into remand, Millard.
Right off. I'm granting those, right? Petitioner rejecting in so and so case. Allegation of the petitioner so and so. When the petitioner has filed an affidavit dated 11/11/2024 inter alia stating agent para 4 Roman 2 para 4 Roman 2. The land council or the petitioner contended that while the petitioner was in custody in relation to GR case number 39/4/2024, 24, police has extracted a confessional statement from him and got him involved in the instant case, and taken him to remand. Petitioner is already in custody since 15/1/2024. 15/1/2024. The allegation collected now 24. How many witnesses are there in this case?
In this case, Miller,
Charge-sheeted witnesses?
charge-sheeted witnesses are Miller. Charge sheet has already been filed, charge sheet, but no charge sheet witnesses has yet been examined, Miller. No witnesses has yet been examined. 12 witnesses are there, but no witnesses has been examined.
There are 12 charge-sheeted witnesses are there to be examined by the prosecution apart from various documents. In that view of the matter, the trial is likely to take a considerable time. Hence, he seeks intervention of this court at this stage and they grant seek for admission of those. Take care. Hello.
Obliged, Miller.
80. Non-APS for the petitioner in the interest of justice urgent after 2 weeks. Yes.
81 ଛୁଟିଆ ମ୍ୟାଟରଟା କାଲି ଥିଲା ପୁଣି ଆଜି କାଲି ଥିଲା 81 ଆଜି ହେଇଯାଇଛି 94.
What to do? 200 matters.
ଛୁଟିଆ ମ୍ୟାଟର
81 your lordship is allowed granting interim pay. 81 your lordship.
Yes, 81. I'll take up. Wait. Yes, I'll take up another 15 minutes.
ମୁଁ ଅପେକ୍ଷା କରିଛି
5-10 minutes. Let us see how much I can reach. Yes. Yes. 81. Yes. 81.
May I please your lordship? This is an application for review your lordship. But the appeal was filed by the defendant.
Mr. Mishra, I can hear it little later because there is no urgency it seems because it is the review petition of 2018. I can hear it after a week or so.
Lordship may fix it at next week, my lord, because
Yes.
I brought it on
I'll
mention.
I'll see.
Pardon, my lord.
Next
The
week,
other
my lord.
matters are here.
Pardon, my lord. Item number 99 may not reach your lordship.
Let me go through.
My lord, already.
Let me run through the list. Whichever is urgent, I'll take it up. Whichever is not urgent, I'll just send them. Just run through the list.
In my case, no urgency.
Okay, then I'll adjourn it. I'll just run through the list. Yes. 82.
May I please, your lordship? My lord,
What modification?
modification, my lord, on condition that, my lord, your lordship granted well on subject to condition that, my lord, we shall furnish bank guarantee of 1 lakh, my lord. And now bank guarantee 1 lakh within 1 month from the date of release, my lord.
Where is that order? Bank guarantee.
8/10/2024, my lord. My lord, that 1 month was completed, my lord, tomorrow, my lord.
I'll extend it.
Yes, and my lord is a retired person. He is unable to pay that money.
I'll extend it for 1 more month. You arrange it.
Your lordship might be remembering after 9 years.
I don't remember. I'll just extend it. Because the condition of paid, I'll extend it. Maybe having some financial difficulty.
Exactly. He has misappropriated 33 lakhs in 8 cases.
Right on. Petitioner in this petitioner is seeking modification of the order dated modification of the condition of bail granted to the petitioner on 8/10/2024. The counsel for the petitioner submits that the condition for furnishing bank guarantee of 1 lakh rupees could not be within 1 month, could not be arranged by the petitioner, hence she seeks modification of the same. For the reasons stated in the application, although I'm not inclined to modify the condition, however, the time to furnish bank guarantee is extended to another 6 weeks. 6 weeks.
Obligations.
Let us make it 8 weeks. Because she will move another application. Better give it 8 weeks. 8 weeks. 8 weeks. Do it. Yes. Yes.
Obligations.
Wait, please, others. Earlier, this one was issued office to the OP2 and 3 now. That is not sufficient.
Sufficient now.
2 and 3.
Both. The notice on the
One is applied for the OP2.
Notice on both opposite party number 2 and 3 is sufficient. However, none appears for them. Hence, in the interest of justice, release the matter.
Interim order passed.
Interim order passed already. Yes.
84. May I please? It is common, though it is a fresh admission.
Yes.
Since I have filed a petition for dispensing with the filing of the Annexure 1, for that reason it has come an order, my lord. Because an application has been filed for dispensing with the filing of Annexure 1.
IA number 2568 of 2024 is allowed. Lease the matter.
Next week, any date of fresh admission?
Hearing on in the category of
fresh admission.
Fresh admission, yes.
Next week, any date, my lord?
He'll give it 85, yes.
This particular matter, the trial of 2016 has been delayed till date in spite of my lordship's order dated 9/1/24, where my lordship directed that the trial to commence.
I'm appearing for the petitioner.
This is sufficiently delayed. My lordship passed an order on 9/1/24. And
So you are appearing for whom?
I'm appearing for the OP2.
Okay. Okay.
Now, my lordship sees the Supreme Court has categorically stated that sufficiently derailed proceedings like these has imposed a cost of 50,000 rupees. And I've given the judgment which my lordship would see at paragraph 13. Only my lordship would see paragraph 11 and 13. That would suffice my case.
Yes.
They have come thrice in 482, once for Cognizance,
Thrice.
and they have completely kept this order away and have snatched an order from the court. It's not a question of smiling. My learned senior, who happens to be a great friend of mine, it's not a question of smiling. How could you keep this order away from the other coordinate bench? It's a very serious issue. It's not the question of smiling. We do file cases for the benefit of the client, but 2016, where my lordships have already passed an order and
Yes.
10 witnesses have already been examined as on date, as I'm speaking, and it has been stayed by the court, by the coordinate bench. It is very, very unfortunate. It is very, very unfortunate, and the Supreme Court has stated that sufficiently derailed proceedings with frivolous application, untenable application, misusing the power of authority would enable him to pay a cost of 50,000.
You are relying upon K. Ravi.
Yes, deeply obliged, my lords, deeply
He
obliged.
wants cost or?
No, not the question of cost. It's the question of 2016. And my lordship's bench has passed this order.
Mr. Raj, just see the time.
Because that time to rise, because of my lordship's time to rise, my lordship is aware and conscious. He's a great friend of mine.
Let us have the pleasure of seeing you in the court.
My lordship will always seek and
Very difficult for us to control him.
85, I knew it might not reach.
This is not my demand. This is demand of your learned senior counsel opposing you. He says that he want to face you physically.
No, my lords,
After 2 weeks. After 2 weeks.
they've broken the house of an innocent
All
man.
right, dismissed, whatever. Allow me.
He wants to see you physically
Sentence.
after 1 week.
If I have suffered,
then
with-
stay
if I have
be vacated.
suffered little bit more.
Lords, let the stay be vacated.
Mr. Rai, if you have suffered with for so long.
No. My learned friend is great in saying so. My learned friend. This is unfortunate.
Continue. And you can't
Very
physically so that.
unfortunate. I should not be saying so. My learned friend is there. He should have assisted the court. No, in fact, as I
Unless
hear,
he comes
I
here,
must
no.
tell my lordship.
He is a
He
good
said, "I am
friend of
not going
mine.
to the
Unless
court."
he comes here, I cannot
No, my
complete.
learned friend said, "I am not going to the court. I cannot defend this case. This is defendless." This is what my learned friend said.
He refused to argue in your absence. Physically, you have to come.
No,
Yes,
my lords, let the
please.
stay be vacated. Let the
Yes.
Yes, my lord. Here in 86 item, I have read it through IA for dispensing with filing of certified copy of FIR as well as charge sheet.
Okay. For the reasons stated in the application, the application is allowed. Leaves the matter for hearing. Okay.
My lord,
Yes.
my case, a date may be fixed.
Yes, sir. Date after 1 week, date will be fixed.
My lordship will fix a date, yeah.
Yes, yes.
87. Pardon me, Lord.
As
Sir,
stress
there is a judgment dated 21/5/2024. 2 years conviction.
2 years.
2 years conviction.
Okay. Admitted, bail granted, realization of fine is at state, call for TRC. Yes.
What is it?
In 87, let him solve a copy of the appeal memo because Union of India is appearing.
Already, sir. Already, sir.
No, since I am appearing, earlier Mr. Gyanaloka Mahato was appearing, has been.
2 times already, sir.
He has already served.
Already, sir.
Earlier council matter, he has been empaneled.
Give one more copy.
All right, I will call it. All right.
Madam, बहुत पूछता.
Okay. I'll hear it later on. Yes.
89.
Here, my limited prayer that I am came against the discharge petition. I only pray that now the man is 69 years.
A copy. I know. I have provided the copy, Lord Sahib.
And he's 1 minute. I'll
69 years bedridden. I want you also may target the trial and to appear through VC, the man, the accused.
You application on health ground 205 will be allowed.
No, but the VC
205 is meant for you like people only. If you are completely, bedridden, then you can't go.
Bypass surgery has been done.
I'll record that and dispose it.
It's a copy will be given, Lord. No, that is there. It's supposed to get.
Mr. Raj, what I'll say is, I'll record his statement and dispose it up. Let him move an application. Let it be decided.
And it may be targeted 3 months or 6 months. That's
to see how many witnesses are there.
It is of the year 2011.
If the lordship permits,
and only 1,20,000 involved.
The relative dispose of, but this is application also there for condonation. It has to be condoned. Why I expect that particular copy? Well, I have to inform to the department that this is the case. I don't have the case number and all this.
Give a copy and take it Tuesday.
No, we'll give copy. This is not no prejudice.
I have already given. Don't wait. Give a copy. What is the big deal? Give a copy. I'll take it on Tuesday and pass the same order. I remember it. I'll not forget it. What I'll do is I will target it because it's the old matter.
Yes.
And I'll allow you to move application under 205. The same shall be considered, keeping in view your health condition.
Agreed.
Yes. And accused statement may be recorded by BC. Accused statement because he is bedridden. He is bedridden.
Little more than you say that I recorded direct the trial court to record an acquittal in your favor.
No, that I can.
Wait, let the trial court will do it in accordance with the law. I'll pass this order, don't worry. Okay.
Lordship may dispose that IA also, that application.
Everything I'll dispose of that day. The main petition I'll dispose of. Give a copy, right?
Yes, today I'll give. My purpose is to inform the department that this is all in this case.
No expert order can be passed. He has to inform.
In this case, and what is the case number and all this thing, what's the matter?
Matter for them.
We have already shot a copy. Now he has come for it.
No. Yes.
What is the receipt?
Receipt is there. Yeah.
Receipt is there. So, government copy.
ଯିବେ ନା ଆପଣ ତ ସବୁ ଦେଖିବେ ଖାଲି ଆଉ କହିବେ Reference ତ ଆମେ ଦେଇଛୁ yes I will serve a copy you do that don't waste time
No, she is waiting. Let us see. I'll hear the mentioning. 1 minute. What is she saying? She something.
So here, my lord, the cognizance of 4988, divorce in 2018.
Yes.
I have also given the charge sheet, which speaks that she does not want to proceed. She has already been remarried. I am the third husband of that informant. She has married for the fourth time. And every occasion, my lord, there is a divorce, permanent alimony. Divorce, permanent alimony.
Judgment is annexed for the divorce already allowed. Under section 20 of the Special Marriage Act.
Mutual divorce.
Yes, 28.
Yes. Let us see. Let us see the. No, forget about charge sheet. Let us see the terms of settlement. Where is the divorce petition?
Divorce petition is under annexure 2, my lord. Condition for your lordship will kindly see. That is
Where does
page 17.
17?
My lord.
Yes. Yes. Where does she says that criminal case can also be?
My lord, that is in the charge sheet I have given, my lord.
Huh?
My lord, this application was filed before filing of the charge sheet.
Where is the charge sheet then? Where is the charge sheet?
That is there.
Final form, yes.
During investigation, my lord.
Where does she say that?
Last she did not wish to run this case for legally further. Charge sheet. Here, certified copy ta achi.
The offence has so established, submitted fully compliant. I have that. Which part of it?
Last beଳକୁ she 13/12/2018 ତା ପରକୁ. In the court of family judge in 13, she does not wish to run the case legally further. No fact of the case जोटी अच्छी.
What are the offences then?
498. 498, 323, 509, 506, 34.
And 66C and 60.
Charge sheet.
Yes, what do you say? It is not a matter of settlement. It is matter on merit.
Because she does not want.
She doesn't want, first of all. There is a separation.
Evidence affidavit is already filed that I am own volition and separate from the marriage binding.
Where does it say?
That is an evidence affidavit filed in my senior. That is annexure. Annexure page 22. If you can
22.
Yes, evidence affidavit submitted by the prisoner 1. Artana Dhal. That is marriage.
Yes, filed it.
Yes, in evidence before current family.
Where is that? Which paragraph?
In paragraph same page, that marriage between the house is broken down, and there is no mental compatibility between the house, and there is no chance of reunion and more. And we are residing separately from the date of marriage. This is stated in the by of issuing affidavit.
Your Lordships, I am appearing on behalf of the opposite party number 2, informant, Your
Lordships. Yes. What do you say?
Lordships, the only problem is that I do not have any issues with regard to quashing of the case, but he has to stop calling and battling me with phone calls and missed calls. That is the only thing. He keeps on calling and disturbing. I am now married again.
Petitioner ରହୁଛି ନା ପୁତୁରା କି କଥା କହୁଛନ୍ତି ନହେଲେ ମତେ ଏତେ anxiety କାଇଁ ହନ୍ତା.
See, the problem is
phone କରିବନି. That is not the point.
I can't pass an injunction order like this.
Lordships may say he will not disturb, or Lordships may quash without saying that he will not cause and he will not disturb the life of the opposite party. That is fair enough.
ये की कथा है giving handle to the informant ये की चट्टा रही सालनी.
After dissolution of marriage, she can marry a number of people.
Fifth one, she has a right to Bharat.
Yeah, move third.
Third, okay, it's all right. We have special affection for you. Out of 4, you are the favorite. That is what is apparent from the thing. I'll pass you out. Hard copy ଅଛି
हाँ हार्ड कॉपी अच्छी मुझे ये जो भी अच्छी नहीं नहीं ये जो चार्जशीट भी
दे दियो
मत चार्जशीट भी अच्छी सर्टिफाइड कॉपी
I'll pass you out. I'll just record that it is expected that you will not harass the victim. I'll just record that. It is expected that you will do that. Behave properly. This is what I can say. Whatever. I can't pass an injunction order. Even if I write.
Only that observation is there. I cannot go beyond that.
I'll record that. Yes. Till today. Then entry motor continue. 99 also. 99. You will fix a date, but wherever there is entry motor, let it continue. Even if you are adjourning, continue entry motor. Okay.
Item number 95.
99. No, it is reconciliation has
Report submitted. I also
failed. Mediation failed. Mediation failed.
Quantum, they demanded high.
He said.
And I also written.
And I has to be decided.
Yes.
Just entry motor.
I know item number 95. Item number 95. Make quick any vote, my lord.
अच्छा
Oh, 3 petitioners, sir. Okay.
Item number 95.
One humble prayer, item 96, my lord. Pursuant to lesser direction, I am submitting an affidavit in support of, in light of judgment passed in Rajesh versus Sneha. I am submitting that.
File it, I'll take it.
Let the opposite party be directed to serve a copy. Let the opposite party be directed to serve a copy.
Give it.
And the matter may kindly be, I'll be deeply obliged if the matter will be kindly posted to after 10th December. I'll be out of station, my lord.
December. Yes.
Item 105, interim order, expires on 11/11.
105.
105.
Acha. Adjourn on request. Entry motor continue.
I beg your pardon, my lord. Item number 95, that providential matter. The lord may fix it to next week.
He will adjust and give it. It's not possible. So many matters I am listing. I'm not able to.
Is that provident matter where the payment has been?
All right, whatever.
Only the instead they have already obtained instruction.
Yes,
Item number 102.
No, 102
Entry order ଅଛି ନା
92 ରେ ଅଛି
102 ରେ ବି ଅଛି
ଜଜମେଣ୍ଟ ସ୍ଟେଜ ରେ ଅଛି
ତ ଶୁଣି ନା ଜଜମେଣ୍ଟ ସ୍ଟେଜ ରେ ଅଛି ଶୁଣି ଦେଲେ ସରିଯିବ କାମ ରିକଲ୍
ଏଣ୍ଟ୍ରି ମଡେଲଟା କେମିତି
311
କାମ ସରିଯିବ ଶୁଣିବା ଟାଇମ ଥିଲେ ତ
ଶୁଣି ଆଉ ଆସିଲେ କଣ ହବ ହାଇକୋର୍ଟ ଯଦି କିଛି ନହବ ଇନଫ୍ରକ୍ଚର୍ସ ହେଇଯିବ ଆସିକି ଲାଭ କଣ
କରିବ This is what is happening.
102 next week next week
Let it be there in the list. We'll see if it can be possible. I'll take it up. Yes.
92 let's interim order continue next week.
All the matter where there is entry model will continue.
What's so item 93? I got to know from court master that it will be assigned to appropriate bench. 93, madam.
Yes, I'll tell you. There is a specific notification that all MLA MP cases will go to a specific bench.
Interim order to continue that.
Go and mention that.
Yes. Grateful, madam.